Good evening, friends. I welcome all the participants to today's webinar on RERA Pathshala. We have one wonderful eminent speaker, CA Aditya, and I think this is a hot subject nowadays. In 2017, when the RERA has come into effect, I think in Maharashtra also we have Maha-RERA, and this is a hot subject nowadays. Even in last week we got instruction from our CP directorate that in the month of May we have to keep this RERA as a RERA Maholsav, and we have to keep this RERA meeting. But in Panvel, I think we are so advanced, and we are keeping this seminar in the month of March. So it's a privilege that we have CA Aditya today in our midst, and I hope we can learn so many things from him today. We have 3 hours session, and obviously he will teach us everything from the scratch. So whoever may be in the RERA practice, they can you can say you can boost your practice, or those who wants to start your RERA practice, obviously he will. This is a very good opportunity, and we can learn from him. I with this I conclude my notes, and I wish all the participants a happy learning, and I request our committee member CA Vallabh to introduce today's speaker. Vallabh, please.
Yeah. It's been a great pleasure for me to introduce our today's learned speaker. Our today's learned speaker, CA Aditya Zantye, is a qualified chartered accountant and has also and is also a graduate in BCom Commerce with distinction from the University of Mumbai. He has also completed diploma in information system audit. He has been in practice since last 7 years, and he is currently partner in Zantye and Company and AKORD and Company Chartered Accountants. He is specialized in the area of RERA advisory, compliances, bank audit, stock audit, tax audit, and GST for real estate sector, project accounting, assurance and advisory services, outsource accounting and corporate law services. He has significant experience in supporting companies with the complex accounting matter under various financial reporting frameworks, including IGAAP, and advising on the wide range of corporate tax issues. Ever since qualifying, he has been largely interested in information technology and accordingly specializes in IT solutions, which vary from system implementation to review, developing customized solution for the clients. He has handled litigation matter before the VAT authorities, anti-evasion authorities in service tax, and before Maha-RERA authorities for major real estate group engaged in SRA and affordable housing sector. He has raised concerns of chartered accountants issuing Form 5 during the pandemic through the representation to Maha-RERA. He is also a faculty at Advanced ITT of Thane branch of WRC since 4 years and ERP and related technologies. Recently, his remarkable achievement in sanction of rupees 170 crores stress project funding for major real estate group in Thane through a special window for affordable and mid-income housing. He has delivered lectures in RERA refresher course held by WRC in the month of July 2021. He has also been invited as a speaker on crucial aspects of RERA at various branches. Currently, he is accountable as a co-convener of the RERA study group of WRC of ICI for the financial year 2021-22. He has been appointed as a treasurer of RERA Practitioners Welfare Association. He has co-authored Western India Regional Council's Maha-RERA Law and Practice book published by the Taxman's Publication Private Limited in 2021. With this brief introduction, I welcome our today's speaker and request him to take the charge of this session. Sir, you can take the charge.
Thank you very much, sir. I would thank Juman sir for inviting me here, and it is indeed pleasure to meet a different study circle altogether. We were not knowing each other, but as a speaker you have invited me, so I would do a justice to this topic and it would enlighten the members regarding this crucial topic, because here the role of chartered accountant is very very important and it is very crucial. As we have the ex-chairman Gautam Chatterjee sir had also mentioned in many meetings that the chartered accountant is pioneer of this particular law. So here basically the role and the importance is such that this certificate is directly we are answerable to the public, wherein in income tax or in GST we deal with the law indirectly, or we don't have a direct answer to the public. But here the final buyer may question us that what is the current progress of the project, why it has been stuck, and in even in the future even forensic audit might take place due to certain lapses in the projects. And hence the importance and the a crucial aspect of the certification and the right from the registration. See, we are one professionals that those are involved right from the beginning, that is registration part, the updation part, issuance of any forms, and the representation part. So every role we can play in this particular sector and in this particular law. So here it is indeed necessary for us to understand this law in a better way and take certain precautions while issuing the certificate. So with this, I will begin with this today's topic. It is RERA ki Pathshala. Herein we will cover the all the aspects of registration, the forms, and the subsequent amendments till date. What are these amendments in the registration or in the forms, so that we will get the complete clarity as to if someone wants to start the practice in this particular area, so he should be aware of what should be precautions, what are the precautions he should take care of, and how to do the registrations, how to issue the forms in this particular law. So this is very important, and hence because of this particular law, there is a change in the real estate sector right from the May 2017, and today now in again May we will cover, sorry, May 2016 we will again cover 5 years. So in May soon there will be a lot of many changes. We are expecting a new website also for RERA, wherein different changes are there. So we have to be prepared because the transparency is increasing day by day. So your precautions needs to be taken on the part of chartered accountants and considering the role of CAs. So let us begin. So to begin with, let us cover the registration part. I have directly brought an application form for the particular project, how it appears and what are the crucial aspects you as a chartered accountant while verifying the project. See, in case of RERA, there are, as you all know, the law is central. It is a central act, but since land is a state-wise subject, hence there is the rules made by the states, and accordingly different states have different rules and the process for registration of the particular project. So in this case, we in RERA was the pioneer of this particular sector based on the registration portal. यहाँ पे जो registration में changes किए, जो शुरुआत से एक process set किया, उस हिसाब से उसको follow करके बाकी सारे states ने वो implement किया. But in case of RERA, we had observed that they have taken a good stand as to digitization of the entire portal of their registration. So there completely it is operated through digital signature. In RERA, we don't have such facility as of now, but in future we expect, because the role and the responsibility is increasing and the transparency. So considering a digital India, we are expecting that more and more such options will be available. We already have GPS tagging, wherein we mention the longitude and latitude of the project, and based on that it can be tracked by the RERA where exactly this project is located. So let us begin. This is the general RERA application form. which once you fill in all the details, this form is applicable on available on the portal. So what all details are mentioned here? The first thing is, here you have to mention the application number. It is already been done by the RERA. Once you apply, you will get this application number. Next is the payment. These are the payment details. How much is the fee, registration fee? You all know that at the time of registration, one has to pay registration charges to the RERA authority. It is basically 10 per rupees 10 per square meter and minimum rupees 10,000. So subject to 10,000, maximum 10 lakhs. So this is the RERA registration fees needs to be paid to the government, and this is automatically calculated. Once all the application is done, you will get a payment screen. You just have to pay that amount, and it is based on the plot area. So please keep in mind that the plot area, it should be as per the approved plans. It should be confirmed by the architect, and all the once you enter that plot area, then subsequently you, if you want to change it, you have to apply for change by paying 5,000 rupees. So in RERA, certain changes are allowed to be updated in normal project update, but most of the changes which are crucial for the part of the project, and it is very important for LOTs, hence those changes are allowed only after paying the fee of 5,000 and application for change. So certain changes such as FSI and certain other details are under section 14 subsection 2. We know that any changes in sanction plan, any changes in or major alterations in the project needs approval of the LOTs. So such same changes can be done only after paying 5,000 rupees to the government. But the registration fee is limited to 10 per square meter and minimum 10,000, maximum 10 lakh. So earlier this 10,000 was 50,000. Initially 1 to 2 years it was 50,000. Gradually for small projects it was very difficult to pay that amount. Hence they have reduced that amount to 10,000. So this is the amount that can be which is calculated. Next is, now suppose the details are of the profile of the person who is registering that project, and that is very important. So your first name, middle name, PAN number, father's name, and any, do you have any past experience? Now in this case, since it is a single proprietor, then you have to mention the details of that particular proprietor. But in case of partners, we need to mention the details of all the partners and the partnership form. So basic KYC of that particular entity is required here in this particular application. So here there is now one question: do you have any past experience? Now what does past experience? Past experience means last 5 years. If the said entity has completed any particular project, then that details need to be mentioned, wherein you have to mention the cost of the project, what was the proposed date of completion, and when it was completed. So what will happen, why this field is being introduced, so that people will have faith in that particular entity and the project. Because if the buyer, as a buyer, if I am visiting the website, then I will come to know that yes, he has completed, he has a history of completion of project, so my money is safe, I will get my final unit. And that is the reason RERA has given this past experience field in this particular form. Next is, are you part of any promoters organization? Those who are entering into this field, they should know that a promoter has to register with certain entities called as special regulatory organizations. RERA has given them authority to regulate, to register these all builders or promoters as their members, so that they can help their members in understanding the law, in getting the project properly updated, and all the facility, background facility, because RERA as an authority cannot reach each and every builders. So they have given permissions to these SROs. They have given certificate based on the certain criteria that minimum 500 members should be there of these particular organizations. And to name a few, NAREDCO, CREDA MCHI Thane, Builders Association of India, Marathi Bankam Vyavsaik Association. These are the SROs which are registered on the portal. Before registration of the project, the promoter has to apply for the registration number of any of these SROs. It is very much compulsory. Then only he can register the project and he will be allowed to register. The number which he obtains from that particular SRO, he needs to mention in his application. So this is all about the KYC. Next is address, the communication address. This needs to be the communication of the official address of that promoter. So this is very important. It should be the registered address on any documents, may it be Shop Act or GST registration. So that or a certificate on incorporation, that registered address needs to be mentioned here. Contact details, the person who will be contacted in case of any issues in the project, that details and the website URL needs to be mentioned in this part. So you can see past experience. In past experience, they are asking project name, project status. Project status, whether it is a new project or it is an old project or ongoing project, what is happening in that project, that needs to be mentioned. Next is proposed. Yeah, so this is related to proposed date of new project. So proposed date of completion, here you have to mention what is the current date of completion. You assume that this project will complete in 5 years, so that date needs to be mentioned in this particular field. See, till the time now in React there are two sections, one is section 6 and one is section 7. So in section 6 they have the authority to extend the deadline to 1 year. So based on the application, he can get an extension of 1 year without obtaining permission from the allottees. So before that, before the date of expiry, if there is any typographical error or if there is any error while entering the date and he wants to change before the date of the expiry, then he can change it by paying 5,000. But once the date is expired, he has to apply for extension of the project compulsory. If he will not apply for the extension, then the project will be termed as lapsed project, and you can all see the lapsed project list. It is available on the website. Recently in Maharashtra, around 3,500 projects were lapsed. Now slowly they are getting it updated and it is getting completed, and they are removing the names from the list of the lapsed project. So here this date is very much important, because this date can be challenged. On the basis of this date, people will book the flats on the project, and this date should be in consonance with the date mentioned in the agreement. So if there are 4 buildings, he can mention different dates of those buildings, but those dates cannot be beyond the project proposed date of completion date. That is very important. After the period of 1 year, he can again apply for extension, but then he has to obtain in the format given. In that particular format, he has to obtain minimum 51% of the permission of the total units sold. Buyer's permission is required, then only he will get the proposed extension. Whatever date he will mention, if the buyers agree, then RERA is not having any issue in giving the extension. Project type. In project type, we have different options such as residential, commercial, commercial. If there are commercial part involved, then you can mention other. So mixed, whatever it is, it is a plotting scheme, then all that type needs to be mentioned in project type. Litigation related to project, it is very much important. If there are any existing litigations in the project, the promoter has to display those litigations on the website. Subsequently, in the complaint, they observe that the litigations are there, but he has not mentioned on the website, then heavy penalties can be charged, because RERA is having the authority to charge penalty up to 10% of the estimated cost of the project. So we are here dealing with the registration part. After that, we will see forms and the amendments in the forms. What are the amendments and what are the amendments in registration, we will see at the time of this registration only. Are there any promoter, landowner, investor as defined under RERA? In section 2, there is a definition of promoter given wherein landowners are also promoter. Earlier, promoter was given a different term called as co-promoter, but later on it was challenged in the court of law, and then the decision was backlashed, and here now there is no such term called as co-promoter, because landowner is also equally a promoter. Hence, since there is no definition as a promoter anywhere, it has been defined in the act. Hence, the promoter, the main promoter, that is the builder, he's the called as promoter, and the landowner is also called as promoter. So based on the agreement, there can be two agreements: area sharing agreement and revenue sharing agreement. So based on that, he can register the project, and the revenue and RERA sharing both can be appropriately registered here. So in case of area sharing agreement, the landowner has to follow the exact rules and the law which is applicable to the promoter. He has to he has to open a separate bank account. He has to operate the bank account as like the promoter is operating. So 70-30%, he has to follow everything. He has to obtain form 3. All the compliances needs to be done on the part of landowner. In case of revenue sharing agreement, the landowner is as partner of the promoter. So all the compliance together as the for the project needs to be applied. No need of separate forms, no need of separate bank account. So as of now, this position is not changed. So landowner also needs to follow the rules and regulations. Then we have boundaries as east, north, south, that is the news, northeast, west, south boundaries that needs to be mentioned. Earlier, the base for this particular boundaries was the certificates issued by architect, engineer. There we would have got these details in the subject clause itself. But now with the latest amendment of 22nd December 2021, the forms are amended, and in that no need to mention the uh, subject clause that we will see in the form. So these details again we have to rely on the promoter, where whatever he will give, that details needs to be mentioned here. Plot and CTS number, everything will be available on the plans and everything. So on that basis you can enter here. Approved IOD, we have approved plans, so on that basis you can mention here. Next is sanction building counts. Sanction building counts, he have to enter the sanction building counts, total sanction. But here there are the details are divided into 3. It is sanction building counts and proposed but not sanctioned building counts. So together there is total building count. So what happens once you mention, suppose there are 3 buildings in the project, as of now approval is for only 1. So in proposed it will be 2, and in sanction it will be 1. And based on that, you can enter the total details of all the 3 buildings, which is very important. That if you cannot, then you have to subsequently register that building as a separate project if you will not mention it as proposed but not sanctioned building count. Then it is very important. So see to it that if there are more buildings in that project, but the approval is only for one of the buildings, you need to properly bifurcate and mention here. Next is any area, aggregate area of recreational, if there is any recreational open space in the project, then he needs to mention these details. It is very well available and it can be obtained. As a chartered accountant, you can obtain these details from the architect. We are no way in going to predict or we have to enter anything here. We just have to take that figure from the architect, obtain it from the architect, and we can enter that details here. Next is FSI details. Now this is very important because here what RERA is expecting, how much is the total FSI that we can know from the approved plans, we can confirm it from the architect, how much is the total FSI available in this particular project. Out of that, there are 2 things. One is approved FSI and other is not sanctioned FSI. So one is approved. So total, again like the building count. So here so and so amount is written in the proposed and so amount is written in the sanction. So later on what will happen, the sanction not yet sanctioned figure will come to the approved figure, and we will get the total FSI. So whatever FSI is available in the project, you have to mention the entire details. Otherwise, if you will not mention here, then subsequently, where if there is any change in the FSI, if there is any change in the FSI, then you have to obtain the permission of the allottees. It is as per section 14 strictly. Any change in the plans, any change in the DC rule, because of the DC rules also FSI was increased. In that case also RERA has clarified in the FAQs also, and it is as per the law that any change due to the any implementation of any rule or law, that needs to be updated here with the proper permission of the buyers, and the application needs to be done by paying 5,000 rupees. So that is very important in this case. Next is bank details. Now in case of bank details, it is not very much I'm going to say the bank details. We don't have a separate banking regulations and all like Gujarat and other states. Many states have, especially Gujarat. But in Maharashtra, we are allowed to update this in normal update. If subsequently the account is changed due to change in constitution or change in certain from LLP to partnership or LLP to private limited. So due to such changes, any change in there in bank account, then he can change the bank details here without applying for change by paying 5,000. But the issue is this bank account should be a separate bank account. Now in RERA Act, it is separate bank account. Nowhere it is mentioned that it should be a escrow account. It should be a banking account. Nowadays, what banks are following, they are giving three accounts: master account, 70% account, and 30% account. Because as per the act, 70-30, it should be automatically divided. So 70% एक अलग अकाउंट देते हैं, तो मास्टर में जब अलॉटीज का पैसा आएगा, it will automatically get divided in the 70% and 30%. So what will happen, we will get a proper idea and verification will be easier for professionals also, so that we will get 70% में कितना अमाउंट कलेक्ट किया है ना, उसका ही अपने को रिपोर्टिंग करना है. That's it. So this bank account plays a very important role in RERA, because here this account, if there is any excess amount lying in this account, the developer can take avail FD facility, but it should be a no lien facility, no lien bank account. It should be no lien bank account, and but there is no protection for the litigation. Now suppose in GST or income tax this account is been attached, then there is no such protection in the RERA law or there is any clarity, because what will happen if this bank account is attached, then construction progress will get affected. So here it is, although there should be no lien, but it can be attached by other government departments, and it is very crucial because it might affect the construction work in progress. Next is project details. Now here the project name, see this project name, many people what they do, they keep on changing the project name. This is not acceptable, because earlier they they give in the brochure name different, and later on some parties get exited from the project because they might be doing it jointly, and now again name is changed. So this should be taken care of, that project name should not be changed frequently. Then type of project, whether it is a residential, commercial, that needs to be mentioned. Then land area, what is the land area of the project, that needs to be mentioned. Total cost, CTS number of buildings, and number of apartments. Now in RERA, apartments has been defined. What is apartment? It consists of everything: shops, units, flats, everything, whatever is saleable in the project, it can be called as the apartment. So here it has been defined. So number of apartments, original proposed date of completion, actual date of completion. Now this is in relation to the past experience, because these project details are very important for the past experience, where what was the original date of completion and what is the actual date of completion. Now coming to the main project, here you have to mention the name, which is the new project you are carrying. So which is the new project you are carrying, the name of the project, what is the name of the building in that particular project. So your building details are very important, and here you need to mention the proposed date of completion. Now this proposed date of completion should not be beyond the date of the completion of the project. That is very important. So ये अगर मेरा अभी 31 मार्च 2022 मेरा प्रपोज डेट ऑफ कंप्लीशन ऑफ द प्रोजेक्ट है, तो मैं 31 मार्च 2022 लिख सकता हूँ बिल्डिंग का, लेकिन 30 अप्रैल नहीं लिख सकता. तो मेरा जो भी एग्रीमेंट्स बायर के साथ होगा उसका डेट ये बिल्डिंग के लिए वो प्रोजेक्ट के डेट के अंदर ही होना चाहिए, otherwise it won't be accepted and it is not even valid and the developer has to face the penalties. Here you need to mention the number of basements, number of plinth, number of podiums, number of slab of superstructure, stilts, and number of parking. So these details earlier we were having, these number used to be mentioned by the architect in his certificate, but now with the amendments this has been deleted, so he don't have to mention the numbers, he just have to mention the percentage of completion of work as on date of certificate. So again we have to rely on the professional and the promoter, whatever is being mentioned we have to mention here, and the approved plans. Yes, so here we have to select what is the type of the apartment, whether it is 1 BHK, 2 BHK, shop, commercial, whatever it is, we need to select. We need to mention the details, what are the, how many units are available, and out of that, how many units are booked, how many units are booked, and how many units are available. So in this column, it is how many units are available, and here how many units are booked or sold. Here we have to mention the RERA carpet area, compulsory RERA carpet area, no super built up, no built up, nothing. Only RERA carpet area which he will mention in the agreement of the buyer, and it should be given by the architect. Next is, there are certain tasks. These tasks and activities as per the certificate. You don't have to work this anything. We have these ready-made details available in architect certificate. So here this excavation, whatever are the stages of the project, it has been mentioned of that particular building. So here you have to just mention the percentage of work as per the architect certificate which is available on the record, and it will keep on changing based on the quarterly updation. So there is quarterly updation requirement in RERA. In RERA we have quarterly updation, so quarterly certain details needs to be updated on the website, and that is very important to understand the progress of the project. So based on that record, based on form 1, that is architect certificate, this needs to be updated, and it is we just have to update in normal progress project update. No need to apply by paying 5,000 rupees. It is just, you just have to delete the earlier percentage and you have to mention the new percentage. Number of garages, covered parking is, if it is available, then you have to mention proposed, how much it is available in the project, what is the status, how much is booked, how many are booked, and what is the work done percentage that needs to be mentioned here. Garages is being defined, parking, covered parking is defined, only open parking is not allowed to be sold. Covered parking can be sold, garages can be sold, and that needs to be mentioned here. Next is development work. Other than the building, what are other facilities being provided that needs to, or what is the status of that particular work, internal and external works, common areas and facilities needs to be provided. This is also completely dependent on the architect certificate, that is form 1. So from that you will automatically get these details and you can fill those details. You don't have to work out by yourself. That building details is just continued here, excavation and steel floor, number of slabs of superstructure. तो ऐसे 10 line items है, उसका हम लोग को percentage देना है. So it is project professional. Yes, Now this information is very important. What is this information? It is related to the architect, structural engineer, real estate agents, contractor, mainly Form 3 and Form 5 issuing chartered accountants. So all the project professionals who are involved, we have to mention their details here, and it will be visible to the public also, who is signing this and this particular form. So why this is important? When the project gets stuck, or if the project is to be transferred to other promoter, or it is lapsed, association of allottees approach RERA authorities, then if the promoter is not traceable and he is not answering, then these professionals, an email is sent to this professional that so and so issue is there in this project. A meeting needs to be set up and physical discussion will be carried out. A designated resolution panel consisting of this existing professional will be set up, and ways will be found out to carry on the project further and see to it that how the buyers will get the unit. So that is the importance of this particular field, that all the details of the project professional, all the chartered accountants involved, all the architect engineers involved will be mentioned here. So at RERA, will at any point of time will get the details readily that so and so person is the professional in this particular project. Litigations, like I said, litigation, what is the current state of the suit, and you have to just upload the documents wherein the current status of the suit is been displayed. So in that particular tab, litigation, we have to mention all the litigation existing as on registration of the project, and subsequently also any litigation appears apart from RERA, because whatever litigation is there in RERA, it will automatically be displayed at the bottom of the page when someone views that project. But other than in consumer court, national redressal forum, or any other courts, if there is any dispute or litigation going on, it is on the part of the promoter that he has to disclose these details. Otherwise, subsequently, there might be heavy penalties, because these details are not displayed and he is taking the booking. That means he is misrepresenting to the buyers, and there it calls for penalty under the act. Now, the documents. Now, in this case, the documents are very important. Documents can be uploaded. The maximum size of the documents is 1 MB. You can upload multiple attachments of 1 MB. So, but it should be clear. The document should be clear, readable, and the fields which are there, you just have to mention, upload the correct document in that particular field. So now you can see that here we have PAN card, that is the PAN card of the firm. It is very important. PAN card of the firm or the JV, whatever it is, whatever you have registered entity, you have to upload that. Details of encumbrances. Encumbrances means any hold on that particular land, or any attachment, or any mortgage of the land. So any encumbrances by any financial institution or any other stakeholder, you just have to maintain, upload that details on the in this particular field. But in case you will ask that if there is no litigation or encumbrances is not there, then in that case the promoter simply have to upload a declaration. There is no prescribed format. It is easily available. You can also write that so and so land is free from any encumbrances. I, to whomsoever it may concern, I declare hereby so and so land, and give the land details. That's it. RERA is expecting that on the letterhead of the promoter. That needs to be uploaded in this particular tab. Next is declaration in Form B. Yes. Now, Form B is the affidavit. Form B is the affidavit. The format is prescribed in the rules. It is prescribed very well. And Form B needs to be obtained for all those persons whose details are being registered on the in this particular portal. Now, if there are 5 partners, out of that, who is the authorized partner? He will give the details on the behalf of the firm. If there are different landowners, So on in that case, they cannot give authority to each other, because everyone, if they are sharing area sharing agreement, everyone needs to give this form B. It is as per the act. However, it might be cumbersome to obtain that particular form B, but currently the position and the act and the rule says that you have to obtain the form B and the bank details. Form B is nothing but he is abiding by the rules. He is agreeing to that 70% will be deposited in separate bank account, so and so conditions. So the liability towards this particular project starts from the date when he signs and pays the stamp duty of this particular form B. So this affidavit is very important. From that particular date, all the liabilities starts. Copy of legal title report. Earlier there was no legal title report format, but later on now there is a prescribed format and proper summarized view. First page, 2 pages summarized view, and then we have to mention a detailed report by the an advocate who is having 10 years of experience. So legal title report format is being given in the orders properly, and that needs to be only used by the advocate. So see to it that you as a registering authority, see, you are registering on the portal, so just don't register that document as it is, because sooner or later it might get challenged. And if you will think as a registrar where my name is there, I'm not responsible. But no, in RERA we had one case when CA was held for registering the same project multiple times. So such issues or some issues you don't know that someone might held you responsible. So if you're taking such assignment, just need to take precaution. Yes, the document, what's in that document, it's not your responsibility. It should be as per the proper format, and you just have to see that yes, the land is in proper name. It should be the proper, there should be flow of title, because that document will itself give you if there is any litigation details or any litigation currently is going on, then such details can be very well obtained from the legal title if there is any fault in the title. And as per the act, we have to obtain a title insurance also, land title insurance also. But somewhere hardly any 3 to 4 developers entire Maharashtra have obtained that insurance. Many others have not obtained because of the premium amount is very high, and later on that premium amount needs to be paid by the association of LRTs. So somewhere it is dispute going on, and the authorities have not yet enforced that particular thing. So here it is very important. Currently it is not there, but legal title reports should be as per the format. And otherwise sometimes I have seen that they have rejected, I mean to say they have sent the document for resubmission. You can upload the document in multiple tabs, so the clarity should not be I mean to say changed. It should be readable to the buyers and on any stakeholder. Building plan approval, IOD needs to be obtained and uploaded on the portal. You have to upload the plan and layout approval. These two things you have to obtain from the promoter, the sanction layout and the plans. You should upload it on the portal, and he should also display it on the project site. That is very important. It is compulsory. Whereas had issued an order also that those plans and all the sanction plan layout approval should be displayed on the project site. Performer of allotment letter and agreement for sale. Agreement for sale should be as per the model agreement. Model agreement is specified, is given in the rules, and it should be as per that agreement for sale. And any contravention or any clause which is not in consonance with the law or the act will, even if it is mentioned by the promoter later on, it won't be considered as valid. It will be void if any show, because model agreement is being given, and if he's inserting unilateral clauses, many times we have seen, we have different judgments that unilateral lateral clauses and cannot be enforced because buyer is not having any authority to change those clauses. So hence model agreement is being given. Now even courts have started raising the concern that there should be a model agreement for the entire country. But since the land is a state subject, it is not possible, or many issues are they are facing. So let's see and wait what will happen in future. Next is layout approval. As I said, you have to upload the layout. उसके बाद certificates. Yes, form 3 TA certificate is required in form 3 for this particular project at the time of registration. But I have seen that many are issuing form 3 without obtaining form 1 and 2 prior, even though the status might be 0 or it is at excavation state. But as per the act, it is compulsory to obtain these 3 certificates. So even though you are registering the project, please obtain the form 3 document and upload, and don't issue the form 3 before you obtain form 1 and form 2. So it is very important to obtain these certificates, and these are required for updation also. Recently we have a circular. Recently, yesterday only, we got a circular that these certificates form 3 should not be obtained again and again. It should be as per the limit. उसमें एक limit देते हैं, तो हम लोग देखेंगे डिटेल में फॉर्म 3, बट उसमें जो लिमिट देते हैं उस हिसाब से ही फॉर्म 3 ऑब्टेन करना है. एंड फॉर्म 3 के लिमिट एक्सपायर होने के बाद ही फर्दर विड्रॉवल्स के लिए फॉर्म 3 लगेगा. तब तक we just have to keep on obtaining form 1 and form 2 because it depends on the project progress. So that is very important. Certificates of architect mandatory for only ongoing project, but now it is being mandatory for all. It is not mandatory only for ongoing, so every time it is mandatory. But architect में first में क्या होता है कि उसमें स्टेज 0 ही होता है. सो उसमें एज सच कुछ डिफरेंस, इट डजंट मेक एनी डिफरेंस अनलेस कोई 8 फ्लोर्स या 10 फ्लोर्स तक बिल्डिंग कंस्ट्रक्ट किया, उसके बाद सेल के लिए ऑफर किया प्रमोटर. Next is CC. You need to obtain the CC from the developer and the promoter, and you have to upload that CC here. That is commencement certificate. And status of conveyance is not necessary at the time of registration. Status of conveyance, it should be updated once the project is complete, and many things that the once form 4, that is architect completion certificate, is obtained, then the liability is finished. No, your liability doesn't get finished until and unless you obtain conveyance, and even after that, once the project is completed, the defect liability period is 5 years in RERA. So your liability remains till the defect liability period is expired, and RERA has specifically mentioned in the one of the orders that the promoter, once the project is completed, he needs to update quarterly the status of conveyance, which many are not doing. So please see to it that don't assume that once you obtain form 4, project is completed. You have to update the status of conveyance, because within 3 months obtaining the conveyance, after obtaining OC, you have to do the conveyance as per the act and the rules. So here there is no excuse on the part of the promoter unless it is in the part of a layout. The building is a part of the layout. So in that case, when the last building is completed, then after that, within 3 months, he can do the conveyance. But otherwise, single building project, he has to do the conveyance. Then we have certificate of engineer form 2. We will see in detail. Certificate of architect needs to be uploaded. That is required at the time of withdrawal and registration. Form 2A is the quality assurance certificate. Certainly there is amendment currently. Earlier we had to upload it quarterly, but now we just have to upload it yearly once. So that is very important. Certificate of CA form 5, that is the statutory audit report. You can call it as certificate for a statement of account on the statement of accounts. So this is very important certificate, and it is available for public to view in the public domain. It is very well available. All the certificates can be easily downloaded by the buyers, only except for form 3. Form 3 cannot be downloaded like this. You just have to apply for public inspection to RERA, then only that form can be downloaded. Next is cost details. Now these cost details it is estimated amount and actual amount. It is very well available in the CA certificate. Both these amounts are available in the CA certificate. Just the promoter needs to keep on updating as on when new certificates are issued. That's it. So these we will see in the CA form. What is the cost elements included in these particular forms. Then in the form B is also displayed here. Once you upload the certificate, upload the registration application, this is the total end screen that yes, I verify and I have uploaded all the details correctly. The land is free from all encumbrances, and I will follow the rule that 70% will be deposited in the separate bank account. So this is the overview of the registration and what precaution needs to be taken while registering the project. One more change is while uploading the document. Now recently they had brought one important document, that is CERSAI. So Central Repository of the Securitization Act. You know that if any interest is being created on that particular land or anything, any encumbrance is there, then on from the website of CERSAI, you have to download that report based on asset based search or data based search, and that report should be uploaded on the portal. It is just, you just have to pay a nominal amount of 11 rupees and it is available for free to download. First they had released a circular wherein they were demanding LOT wise also. See, so if any LOT is availed housing loan on that particular flat, that report also need to be uploaded by promoter on the portal. But later on they changed that circular and now it is no longer required to update it LOT wise, but only for the entire project. If there is any encumbrance by any financial institution, you need to upload that CERSAI details on the website. So it can be easily downloaded by the LOTs. And before buying, a buyer can do an informed decision. So that is very important. So this also calls for an assignment for verification of what details are mentioned on the project. So this is particular area. Why I am saying that? Because I have seen that many buyers don't know the meaning, even though this website is there, all the details are there, but still people are just saying yes, हाँ ये registered है. No one is exactly going in detail. अरे इसमें litigation क्या है, earlier order क्या है. See, even if we buy a certain vegetables, we think twice. और हाँ इसमें इतना है, इसमें इधर अच्छा दिख रहा है. But while buying the flat, we need to take more precautions, right? Because hard-earned money is been invested in that particular flat or unit. So it is better that you should not depend on the promises or the details made by the given to you at the time of buying. You should go to RERA website, see what he has mentioned, a proper analysis, or the I would prefer that the buyers should ask the professionals like CAs, advocates, and they should get the scrutiny of that particular project done, so that in future they are not into any trouble and avoid the cumbersome litigation process, because there are many complaints currently pending in RERA also. So somewhere it is not possible also, and many the time lapse period is increased to 4 to 5 months of first hearing. So it is very difficult. So before booking itself, many precautions if taken by the buyer, then it will be better, because many promoters have registered ongoing and they ongoing project and they promote the project as a new project itself. So later on we understand that this project has been started in 2013 itself and they didn't got the permission, and then they offered it as a new project. So somewhere they offered it ongoing, but to the buyers they are representing it is a new project, because once you register an ongoing project, then only you can go for sale and everything. So but earlier litigations also need to be checked by the buyer before buying that particular flat. So this is the overall overview of the registration part. And if we want any queries to be taken currently relating to registration, we can take. Later on we can move to forms.
As of now, there are no questions. Let me check in the chat or question section.
Okay.
In the meantime, can I ask one question?
Yes, sir.
See, initially, when in RERA, the certificate was showing that the completion date was 31st October 2022. But because of this COVID, I think it is extended now. Now, when we check the same project, it is showing 31st October 2023, 1 year. So, but there are no details available why it is extended or whether we
Okay.
can check that.
Yes, as per the authority, they have given a 6 months extension 2 times. So they have extended that in the RERA project itself, and automatically the certificates were generated. But there was a criteria that all those projects whose registration, whose expiry date was between that period after 30th April and so on, between that period, if the project was expiring, then only they gave them an extension and automatically generated a revised certificate. So if you have the revised certificate and the extension, if there is an extension, see, there are two different things many people don't know. First date is the proposed date of completion, which he registers initially at the time of registration. There is a subsequent revised date of completion. That date is not automatically generated. It is the promoter who has applied to RERA for change, and that can happen anytime between the project expiry, project date and date of registration, and date of expiry. Between that, he can change that date if there is typographical error and all. But once the expiry date is over, then he has to compulsorily opt for extension. He cannot go for normal application for change. So in many projects, you will see 3 dates on the application portal page. One date is revised date, one date is date proposed date of completion, next is revised date of completion, and third one is date of extension, expiry of the project, extended date of expiry of the project. So these 3 dates means these different position in the law. So here the extension is given by the authority and certificate is automatically generated, and once you search the project registration number, there you will get this extended certificate.
That
And as per
extended
section,
certificate.
1 year is allowed to extend.
So that means this is a general permission given to all the builders for 1 year
Yes, yes. So
due to
the
COVID.
general given the extended part was general permission for all the projects, and later on also those who have applied for section 6 also, they give the extension to 1 year, and after that they have to compulsory obtain 51% permission.
Okay, thank you. Sriyan sir, you
Aditya,
have any?
yeah. Aditya, can I ask?
Yes, sir.
Uh, yeah, Aditya ji, my question is not exactly relating to the RERA, but it is indirectly related to that because in Navi Mumbai, before starting of the project, the MPC, the NOC from the MPCB is required, Maharashtra Pollution Control Board, and they have asked us to submit the project cost statement, which is certified by the chartered accountant. Okay. Once we get that MPCB certificate, then the builder can move for the commencement certificate to the corporation. Okay, and then this RERA will be coming to picture once the CC is received. So my question is, when we have to submit or certify the statement, which has to be submitted to the MPCB. So basically, can we certify such a statement, project cost statement, as a chartered accountant relating to the project? And second, if the document which is submitted with the RERA later on differs with our project cost statement, which is submitted with the MPCB, okay, then what will be its implication?
Okay, so basically before starting any project, first of all, we cannot certify the estimated cost at all. So, but there was one committee meeting, I had put it in the book also, wherein I found this note in that proposed committee meeting that if a chartered accountant is certifying the estimated cost of the project, then he should not vouch for the financial accuracy of those figures. So he should very well clearly mention this. But RERA, as a RERA, in the RERA, we are not at all responsible for this estimated cost, because we have, for the construction cost, we have to depend on the engineer, and other costs we have to be dependent on the promoter, but we are only answerable for the actual cost. So this estimated cost is submitted to the MPCB and RERA will differ, then we are we are not responsible for it, because estimates are bound to change and it is depend on the current situation. As on this date, what is the estimate, so it will keep on changing over the period of the project, and RERA is given that facility that if you want to change the estimated cost, you just have to pay the 5,000 rupees and you can change that cost.
Acha. Can same person sign both certificates, MPCB certificate for project cost certificate and to the RERA?
Yes, no
Okay.
issues.
Okay. Yeah, thanks.
I think one question is there, whether the landowner is required to required separate registration or in a single form application can be made along with the builder.
No, the landowner is not required for separate registration. As per the law, what RERA is having a view that landowner's liability is based on the agreement between the promoter and the landowner. But registration is for the project and it is not for the promoter entity. So single registration need to be obtained, and there are fields wherein we have to make the main promoter and the co-promoter as the landowner, wherein the tab is only co-promoter, but in actual definition there is no co-promoter. Just to differentiate, they have given promoter landowner and promoter, so that two field needs to be maintained. All others compliance such as obtaining form 3, audit and everything applies to the landowner, but the liability is as per the agreement between the both. So as per the development agreement signed between two of them, it is very important to observe that according to that the liability will differ. And yes, although the landowner is not responsible, if there is any issue and the buyer demands from the landowner for the units which he has sold, so he is answerable to the principal amount of to be refunded. But for other interest and compensation is on the part of the promoter, that all the delay has been on the part of the promoter, so he has to pay. So that is the role of the landowner in the particular project.
Thank you. I think there are no other questions related to this section. If there are any other questions, we can take at the time of question answer session. The last.
Okay, fine.
Samir sir, you have any questions?
Yes, Joman sir, I have one question.
Yeah, please.
Now, in New Mumbai area, in case of Ulve, the projects are under that funnel area of Airport Authority of India. Okay, so there are some projects which are not getting NOC from the airport authorities due to the height restriction, because the landing area has to be clear. So in some of the cases, we have seen that the uh, delay has happened because of such NOCs are not issued by the appropriate authorities in spite of submitting the documents, and that below is delays beyond this 1 year extended period. So in that scenario, what as a CA and of course the builder should do?
Okay, so in this case, basically, what is happening, actually, Section 32 talks about authorities to be suggesting to the government for improving single window clearance and everything, and all such time lapses in the project approvals. But currently, under the authority level, currently the disputes are only between promoter and consumer are entertained. But for the purpose of development of the real estate sector, there is no suggestion on the part of the authorities being given to the government currently. So we have to wait, because many representations are being done that RERA, because the name of the act is not only Real Estate Regulation Act, it is Real Estate Regulation and Development Act. So the development work somewhere to stop the litigation at the beginning itself, and for promotion of fast approvals is not yet been done. So just a representation to the authorities can be made, and then we have to wait for further decisions, because as of now we don't have any authorities to fast track the approvals.
Okay. Thank you.
I think you can move.
Okay, sir.
Okay. We'll take at the end of the sessions if there are any other questions related to this particular part.
Okay. So let's move on to forms. Yeah. The forms issued in case of RERA, we are going to see the new forms itself, and in those forms we will see one by one what are the contents they have given to us, and then we will see the PPTs relating to those forms also. So the new forms, all the forms are issued after due consultation with the stakeholders. They had given it to various SROs, the professional bodies, for any suggestion relating to those forms. I was also involved in that suggestion part, but certain suggestions were kept on hold and certain suggestions were incorporated in these particular forms. And now the forms which have come into practice is somewhere those forms are very cumbersome on the part of the chartered accountants to verify, because if you will see that the individual chartered accountants or the firms are uh, do the certification for mid-size or small size clients, and still till now they don't have those regulations or properly incorporated in their books of accounts. So such details are very much not available what the RERA is expecting. So it would be better, whatever you have the details on your record you obtain from the promoter, just disclose that, and for everything else you have to disclose your observation and comments. That is very much important, because later on how you have certified that particular certificate, on what basis you have drawn the inference, will decide the future. I would, right from the beginning, I have mentioned that, see, at the time of the registration of the project, you cannot tell that this builder is going to lapse the project, or he is not a proper builder for particular project. So in that case, before accepting any assignment, do certain pre-scrutiny that what is the history of this builder on the RERA, whether there are any projects he has completed, what is the status, what are the litigation, how many buildings are stuck. So you will understand the characteristics of that particular project and that particular entity, what is the approach of that builder. So in that case, based on that, you have to change the intensity of your certificates and your observation and comments, because we are no way going to obstruct the business or working of the project. We want, the ultimate aim is to hand over that unit to the final buyer. See, this is the only law wherein we are directly exposed to the end buyers. So in that case, our responsibility has increased manifold, and I consider the professionals the eyes of RERA authorities. Through our eyes, they will see with that to that project whether the project will get completed or not. So before accepting, many are not taking NOCs. See, right from the beginning, I'm saying that NOC from previous chartered accountant is must, especially in these cases, because you don't know with what intention he had issued the certificate and why he left that particular assignment, or why promoter has approached to you. So before accepting any such certification, please see to it that we have to obtain the NOC from earlier chartered accountant, and it should be on record, because this is a project spread 4 to 5 years. It is not that every year you are filing for that particular year only, because once a project is stuck, all the 5 to 5 years will be done. So in that case, all the certification, all the project professionals involved in that particular project will be answerable to some point if it is not properly. मतलब क्या, अभी उसने पूरा पैसा निकाल लिया और वो बोल रहा है अभी मेरे पास पैसा ही नहीं, तो then there will be some issues ना, कि वो पैसा सच्ची में उसने प्रोजेक्ट पे किया था और अब सेल नहीं हो रहा. See, there is genuine issues also. अभी सेल नहीं हो रहा है, currently the market is sluggish for small buyers. Many places the जो छोटे buyers है, छोटे promoters है, उनका project stuck हो गया because sale नहीं हो रहा. So that can be understood, but the funds which are collected from the already sold unit should be used for that project only. That is very important. So let us begin with the certificate. The first certificate in this particular mechanism which we have to follow is the architect certificate. Next is engineer certificate. उसके बाद engineer certificate मतलब form 2. Then we have form 2A, that is the quality assurance certificate, and then we have form 3 issued by chartered accountants. उसके बाद form 4, that is issued by the architect, again architect, and it is the last in hierarchy, which certifies that yes, the project is fit for occupancy, it is complete in all respect. And we have the certificate of statutory auditor. Now it is changed to annual auditor. So this certificate again is issued by a chartered accountant, but that chartered accountant should not be the same person who is issuing form 3. So these are the professionals involved in this particular entire RERA mechanism set by the act and the rules. And in this case, the role of these professionals have increased with the new amendments, because they are asking in detail, and the expectations from the CAs from form 3 and form 5 have increased specifically. So first, I'm not able to open 2 minutes. Yeah. So let us see the first form. This is the architect certificate to be submitted at the time of registration of ongoing project and for withdrawal of money from designated account. So this certificate needs to be submitted at the time of registration and withdrawal of money from the designated bank account. It is to the promoter, addressed to the promoter. Now this thing, subject certificate of percentage of completion of construction of work of project name having Maharera number. Earlier, the subject clause were different. He used to certify in subject clause. He used to mention that what is the a plot area, what is the northeast west south boundaries, what are the latitude and longitude, and where it is situated, everything. So subject clause थोड़ा बड़ा था, फिर बाद में उन्होंने वो अमेंड कर दिया, और ये अभी ये सब्जेक्ट क्लॉज इतना ही बता रहा है कि द परसेंटेज कंप्लीशन ऑफ द कंस्ट्रक्शन ये प्रोजेक्ट नंबर है, दैट्स इट. जब भी रजिस्ट्रेशन के टाइम पे तो अप्लाइड फॉर आएगा, सब्सिक्वेंटली ही शुड मेंशन द प्रोजेक्ट रजिस्ट्रेशन नंबर. दोज हु आर obtaining this certificate, please see to it that he should mention subsequently the registration number of the project. So this is very important, and but the details on the website still remains the same. We have to mention latitude and longitude, then GPS details, everything needs to coordinates needs to be mentioned on the website. So for that purpose, we again have to be dependent on the architect and the promoter. Next is what is he saying in his certificate. See, we are not in no way going to judge him on the basis of technical specification, because we are not qualified for that we will teach him his job. But as a chartered accountant, the most important responsibility on your part is to mention any discrepancy in case of form 1, form 2 and form 3. So very important that if there is any discrepancy you observe, so you have to mention that in form 5. So that is the reason you should know what exactly this form speaks about. So here I or we have undertaken assignment as architect or license certificate for so and so number based on the site inspection with respect to layout. Now this is an important change. See, those who will compare one-to-one the forms, they will understand the previous form and the amended form, that small changes are being made, but which has great impact. Earlier, this layout word was not there. So what would used to happen, he has to issue this certificate building wise. But now the layout option is being given, so he can issue this certificate layout wise also. But since we are registering the building wise details on the portal, we require this certificate building wise. So see to it that you get the certificate building wise in case of multiple buildings in the project. Then we have table A. This is a common table. This is not new. This table was right from the beginning, but there are certain changes. This table also can be given now. In this layout word has been added. Now, instead of numbers, see here he used to mention number of basements, number of podiums, but now he just have to mention the percentage of the actual work done. That's it. So everything, all the stages, he needs to mention the percentage completion. So table A comprises of the percentage completion of that particular building or the layout. Common areas, internal and external development works. I have you have seen this on the registration portal also, that these details were there. You will get these details from this certificate. What is the status, whether the internal roads are being provided, what is the percentage completion of that road, and details that it is under construction, work will be done as per the sanction approval plans, or whatever it is. It should be the details need to be mentioned of the percentage which you are specifying, at what stage it is. So that details need to be mentioned, and same needs to be uploaded on the portal also. So these are just the details. So architect certificate is very short. It just speak about the percentage completion, table A, and table B is for the internal and external development works of the project. Most important change is this, that now he has to get it agreed and accepted by the promoter, and this has been added in all the certificates. Right from form 1 to form 5, everyone has to obtain agreed and accepted by signature of the promoter. So without this, if you will upload the certificate on the portal, it won't be considered as a valid document. So this responsibility is casted on the professionals that see to it that this certificate to be agreed and signed by. Somewhere this might create issues, because we as a chartered accountant, we have certain observations or comments on that project, and the promoter might agree, not agree. There might, so it is better to discuss the draft of the certificate earlier with the promoter, and then get it agreed and accepted and signed by the promoter, and then only you can upload it on the website. But without this, it won't be considered as a valid document. So this was form 1. Let us quickly go through the changes in summary view. So form 1, architect certificate, plot details, latitude and longitude, area, news deleted from the subject clause. Certificate can be issued for the entire layout. So certificate can be issued for the entire layout instead of building wise. List of technical professionals. So list of technical professionals. Earlier he used to mention that so and so person is the structural consultant, so and so person is a surveyor. These details he used to mention. But now that is being deleted. But state promoter has to upload it on the website where the professionals list is to be given. Number of basements, podiums, plinths, and slabs of superstructure is deleted. So that has been deleted. No longer need to be mentioned. Only the percentage completion of the work needs to be mentioned. Counter signature of promoter is required. Yes, counter signature of promoter. Without that, the certificate won't be considered as valid. Before starting with form 2, let us have a view of the form 2. So form 2, in case of form 2, you will see it is an engineer certificate to be issued by the second professional as specified by the Act. This is also required at the time of registration and at the time of withdrawal of money from the designated bank account. So that is very important. You need to obtain these certificates, and without that, you won't be allowed to withdraw the money from the bank account. Here also the subject clause in line with the architect certificate. पहले ये भी यहाँ पे भी सब्जेक्ट क्लॉज था कि प्लॉट एरिया डिटेल्स एंड सारे न्यूज बाउंड्रीज वो सब कुछ यहाँ पे भी मेंशन करना था, अब जरूरत नहीं. Next is here what he says that we have undertaken the assignment of certifying the estimated cost. See, it is the engineer who certifies the estimated cost and not the chartered accountant. So construction का जो भी estimated cost है प्रोजेक्ट में वो इंजीनियर ही सर्टिफाई करेगा, और कंस्ट्रक्शन के अलावा जो भी एस्टिमेटेड कॉस्ट है दैट विल बी गिवन टू यू बाय द प्रमोटर एंड इट इज बाउंड टू चेंज. Estimation is based on the certain predictions and future estimation, so on that basis it can be changed. We have undertaken assignment of certifying estimated cost. We have estimated the cost of civil, MEP and allied works required for completion of the apartment, proportionate completion of internal and external work. See, architect gives you the a table A, he gives you building wise status and then internal and external, and he gives the building wise status of civil, MEP and allied works and the proportionate completion of internal and external works, but the cost part. So that is very important. He gives you the percentage of the completion. Here he gives the estimated cost of that particular completion. So here it should be as per the estimated cost of the everything should be as per the agreement for sale. Now this is added. This was not there in his previous certificate. Slowly and gradually the importance of agreement for sale is increasing. So in this case, you will observe that as per specifications mentioned in agreement of sale, this has been linked to his certificate. So later on he cannot say ये तो cost नहीं consider किया, ये तो बाद में आया. Promoter cannot escape from his liability, and in act all the liabilities are related to the estimated cost. What is estimated cost? It is the total cost involved in the development of the project. Although it is said that total cost involved in the development of the project, but two cost elements, that is commission and the brokerage and the advertisement expenses or marketing expenses, are not considered as a part of the project cost. He has to bear it from the 30% account. He cannot withdraw that amount from 70% bank account. So as per specification mentioned in the agreement of sale, I am certifying the estimated cost. Our estimated calculations are based on drawings and plans and the quantity required as surveyed by the given by the quantity surveyor. So any separate quantity surveyor or architect, he can mention that details here. We estimate total estimated cost of completion of the aforesaid under the reference of total of table A and B. At the time of registration, the estimated total cost is reference to civil. See, the entire total cost will come here. Of the table, total of that particular table estimation cost is you have to mention here, and then total cost incurred till date. That means the actual cost incurred till date. मतलब अगर 100 यूनिट्स परचेस किया है प्रमोटर ने, लेकिन साइट पे एक्चुअली 80 यूनिट्स यूज हुआ है, तो वो 80 का जो कॉस्ट है वो यहाँ पे आएगा. That is the estimated cost incurred till date is calculated at rupees dash. So above we have estimated cost and here we have the actual cost. वो estimated में से कितना incur हुआ, उसके बाद तीसरा पॉइंट में आएगा the first cost, estimated cost minus actual incurred, the balance cost. So these three elements, first is estimated cost, next is actual cost, and then after subtraction you will get the balance cost incurred to be incurred for that particular project. And then he is certifying that everything, I certify the work of the apartments is as per the agreement for sale. So total summation of total of table of A and B, table A and B is being given here. So let us see what is table A and B. So in case of table A, again he can issue the certificate layout wise. It is given very well allowed to him, but it is expected that he issue the certificate building wise, because in our certificate form 3, where there is SRA development, there is redevelopment. So there we should know how much is the cost incurred for rehab building and cost incurred for the sale building. So this two separation is necessary, and it can be obtained only from form 2. Next is total estimated cost. Here it will come total estimated, then cost incurred as per the till date of the certificate. What is the work done in percentage? Balance cost to be incurred. So here, after subtracting this, you will get the balance cost. Now, fifth point, cost incurred on additional or extra items not included in the estimated. See, certain cost which was not included in the estimated cost, and it can be included in the project cost if it is certified by the engineer. Yes, these are the additional items which promoter later on decided that he will give to the allottees, and based on that it is based on the actual cost incurred. So यहाँ पे भी आएगा वो cost incurred हो गया on the basis on the additional item, and again it will be there in the internal and external development. So दोनों जगह पे है, दोनों जो भी ऐसे additional cost है जो estimated में उसने consider नहीं किए हैं, वो यहाँ पे separately आ सकता है, and that can be very well incorporated in our certificate, that is form 3. I will show you where exactly they have given that field. So first was relating to that building, what was the cost. Next is internal and external. See how it is being arranged. Architect बोलता है कि building का इतना status है, engineer बोलता है इतना उसका cost. Architect बोल रहा है कि internal and external development works का ये status है, और engineer बोल रहा है ये उसका cost है. So very well, the percentage and this can be linked. We are not going to study in detail because it cannot be linked. One is based on technical observation, other is based on factual data on basis of the books of the account. So it is somewhere not, you cannot do RECO and everything. But yes, this might give you a stage. हाँ, इतना इसका इतना काम हो गया. So these are the two tables. Summation of that will give you the details in the above fields. Once that is done, again this certificate needs to be agreed and accepted by the promoter. So signature of the promoter is very important. Yes, one more table. One more table is very important. Table C. Table C पहले से था, सिर्फ उसमें insert क्या किया है, this one. जिसका भी कॉस्ट इंजीनियर ऊपर एडिशनल आइटम्स में इंक्लूड करेगा, वो जो कमोडिटी या सर्विस जो भी है उसका डिटेल उसको देना पड़ेगा कि कौन से आइटम्स है जो वो इंक्लूड कर रहा है, वो उसका अमाउंट के साथ यहाँ पे देना पड़ेगा. बट रेरा चेंज्ड a word, that is they added a deleted items word. What used to happen, एस्टिमेटेड कॉस्ट रजिस्ट्रेशन के टाइम पे एक बार सर्टिफाई किया इंजीनियर ने, उसके बाद सब्सिक्वेंट चेंजेस अगर प्रमोटर ने कल डिसाइड किया ये मैं नहीं दे रहा, तो उसका कॉस्ट तो एस्टिमेटेड में आ गया, लेकिन प्रमोटर वो नहीं दे रहा है. समवेयर इट इज नॉट गिविंग अ पैरिटी. In that case, those items which promoter earlier had considered in estimated cost, but later on he is not providing those items, it is being deleted. So accordingly, the cost also needs to be changed. That needs to be also deleted from the cost, and that details also to be given in his form. So this is an important change. Keep in mind that if these details are there, then accordingly changes to needs to be done in estimated cost. So this was all about form 2. Let us check the slide. What are the changes? Yeah. So form 2, plot details. Again, these are common. Certificate can be issued for the entire layout. Then list of technical professionals deleted. Here also it is common. Estimated cost of civil, MEP, allied works, internal and external works as per the specifications mentioned in the agreement for sale. So agreement for sale ये बहुत important है, because now the importance is growing because of model agreement. So all the disputes, RERA had set up a committee to decide the model agreement changes, because lot of litigations were there with respect to model agreement. Hence they are linking these professional certificates also to the model agreement, and here you will get the details wherein he is specifying that all the specification which are being promised, I have considered that cost only in the, and it is very well as per the agreement for sale. Yeah, the actual cost, estimated cost will be as per the inspection and everything as per the agreement self sale, and actual cost incurred to be on the basis of, earlier the wording were actual cost incurred on the basis of estimated cost, but later on now they have changed it, actual cost incurred to be on the basis of input material or services used and unit cost of these items. So many projects I have observed that engineer is not having any working with him, and this might give might create issues in future if the project is stuck. So it is better that after proper working only he issues this certificate. So they have changed the wording that yes, you should have an actual, see, chartered accountant can verify from the books of account, but engineer also cannot just blindly take the figure and mention that figure in his certificate. He has to certify it on the basis of the materials, services used and the unit cost of those items in that particular project. So this is an important change. So please see to it that as a registering person or updation, if you're getting updation or certifications, see to it that there should be certain working on the part of the engineer on the basis of which he is issuing that certificate. Complete project as per approved drawings and specification mentioned in the agreement for sale. So he's certifying that the project will be complete as per the approved drawings and specification mentioned in agreement for sale. Amendment in cost incurred or to be incurred due to deviation in quantity required or escalation of cost. So there can be any deviation in quantity or escalation of cost, so that can be changed in his certificate. And whenever there is any estimated cost change in the engineer certificate, that needs to be changed in your certificate and subsequently on the portal. So basically portal पे change करना जरूरी है, क्योंकि यहाँ पे 5,000 rupees pay करके you have to give the explanation why you are changing that cost. So in that case only proper explanation and proper details should be there. You can change the details on the website. Deviation in material used to be reported. Any change in the materials or any issues in the materials, you have to report. The form 2 engineer needs to report in his certificate. Local authority license number, if applicable, needs to be mentioned on the certificate. And like I said, deleted items to be mentioned in table C. Counter signature of promoter, he also has to obtain the signature of the promoter. Next is form 2A. Let us see form 2A. What is this form? See, this form is introduced for the purpose of quality assurance in the project. Yes, the buyers are getting the unit, and to avoid litigation relating to the defect liability period or the grade of the material used in the project, they are obtaining this certificate from the site supervisor and engineer of the project. And it is very important. So, but the issue was This certificate was issued quarterly, was supposed to be issued quarterly, and somewhere it was difficult for on the part of promoter to obtain this quarterly, and once a material is used of certain grade, then subsequently he cannot keep on changing that grade. So that is the reason RERA realized that, authority realized that it is very, very difficult on the part of promoter and the professional also. So now this certificate needs to be obtained only once at the end of the financial year. It should be submitted at the end of the financial year, and no requirement of submitting it quarterly. Subject certificate of quality of materials used and quality. We are not going to go in detail of this certificate, because this is not we are not going to comment on this particular certificate, or we are not the persons who understand the grade, quality and everything. So it is the best person, the engineer himself, who can issue this certificate. But the change is here in this case, the first point here it was in detail कि सीमेंट क्या है, क्वालिटी ये क्या, वो क्या, ये सारे कंस्ट्रक्शन मटेरियल्स क्या है, अब उन्होंने सारे कंज्यूम कर दिए इसके अंदर. I hereby certify that all construction material, fixtures and fittings with regard to the flooring, electrical, sanitary fittings, etc., and amenities to be provided by the promoter in the said project building and the apartment are as per specifications mentioned in Annexure F of Agreement of Sale. So Annexure F, जो पहले सर्टिफिकेट था फॉर्म 2, उसमें भी देखोगे तो एज पर स्पेसिफिकेशन इन एग्रीमेंट फॉर सेल, और इसमें भी Annexure F as per agreement for sale. So this is very important that he don't have to comment individual material wise. Everything उसमें सारा आ गया, all construction material बोल दिया, मतलब बात खत्म. It is of good quality and grade, and everything is proper in this project and there is no issue. So here this quality assurance needs to be given at the end of the project. And see, they are asking the cell number and office number, everything of that particular engineer, so issuing the certificate. And the records, should be preserved up to the defect liability period. So at least 5 years he should preserve this record. So you will understand that if later on any dispute arises, then which certificate will be dug up for the purpose of checking that whether really the quality of the material was up to the mark. So somewhere this might reduce the issues of leakages, and many buyers are facing those issues later on. So now there is some protection as far as the certificate of engineer is considered. Quality assurance, it is plot details. Here also the details are deleted to be issued yearly. Material wise details are deleted, and he has to comment on all the construction materials. Specification as per Annexure F of Agreement for Sale, if there is specification mentioned, but small builders or promoters generally do not specify what are the specification is going to give. So in that case, if there is no specification, it should be as per the industry standard. So he has to comment on two things, that is it is as per the agreement of sale as per Annexure F, and if there is no specification, it should be as per the industry standards. And counter signature of promoter, again here it is required. Now the important certificate, that is our certificate, which is Form 3. See this, and to proceed with, here also it is required for registration of the project and withdrawal of the money from designated bank account. So this is very important. This certificate gives the limit and it will enable the promoter to withdraw from the bank account. तो यहाँ पे ये सर्टिफिकेट में सब्जेक्ट क्लॉज नहीं था, तो बाकी इसमें सब्जेक्ट क्लॉज था, वो छोटा कर दिया, वो निकाल दिया पहले वाला, और इस सर्टिफिकेट में सब्जेक्ट क्लॉज नहीं था, वो इंसर्ट कर दिया. Now according to this, they have added an important word that said, what is this certificate? It is financial progress of the work of project. So we are certifying financial progress. Architect is certifying percentage completion of the project, and engineer is certifying the cost of the project. So these three is very important, that we are certifying the financial progress of the project, and this word is very important in this particular certificate. Next is, this certificate is being used for another word added in this new format is RERA compliance. What is RERA compliance? RERA compliance means required at the time of registration, at the time of withdrawal, to be submitted to the bank account, and required for quarterly compliance also. So this is called as, together it is called as RERA compliance. For these things, we require this certificate, and it has to be uploaded on the portal by the promoter, and being developed by the promoter is based on the records and documents produced before me, an explanation provided to me by the management of the promoter. Here, first we only had one table, and we had two columns, that is estimated cost and actual cost. Now we have 7 tables. In this case, what they have done, they have separated the estimated cost and actual cost. Why? There is a logical reason, because the first thing is the estimated cost comparison of the engineer and the chartered accountant. Actual cost is no longer required. So that is very important. That is an important change in this particular certificate. Let us see the first table. It is estimated cost of the project. Estimated cost at the time of registration, it needs to be mentioned in this particular field. What estimated cost? Cost is dependent on the land cost and the construction cost. However, I said to you that estimated cost as defined in the act is, it considers total cost required in the development of the project. To develop total cost मतलब वो एडवर्टीजमेंट और ये भी आ जाते हैं, बट रूल्स ने स्पेसिफाई किया है कि नहीं लेना है तो नहीं लेना है. दैट इज द रीजन ओनली 70% अकाउंट कैन बी यूज्ड फॉर land cost and the construction costs. That's it. In land cost, the A part deals with value of land as ascertained from the annual statement of rates. That is RR value. Now, the definition of land cost given in the amended rules and the certificate is not matching, because in amended land cost in the rules, certain items were deleted, but in the form it is still part of the form. Because of this, there is dispute, but as a chartered accountant you have to follow the form only. That is the regulation. As per the regulation, you have to stick to this form and you have to issue the certificate. So first is point A, value of land as per a certain ASR. If you have got the land as per gift, inheritance, or free of cost, or it has been joint development agreement, then in that case the RR value needs to be considered. Now many of them have a doubt that the actual cost of land, purchase of land is higher, but as per rules they have, and the regulations, they have clearly mentioned that you have to consider the RR value only. Now what is the issue? Even though the purchase cost is higher, still I will consider the ASR value. The reason is, if the developer will be allowed to withdraw the entire land cost at the beginning itself, then there won't be any responsibility on the part of the developer, because अभी समझो 8 करोड़ में लैंड परचेज किया, तो 8 करोड़ का तो स्ट्रेट अभी उसको रजिस्ट्रेशन के टाइम पे लिमिट मिल गया, तो 8 करोड़ जब तक हो नहीं जाता है वो विड्रॉ करते जाएगा and he will completely withdraw his land cost at once. So to restrict him, the purpose was to restrict him and to let him withdraw only to the ASR value, restricted to ASR value. Subsequent amount can be withdrawn from 30% account also. 30% भी तो दिए रहे ना उसको withdraw करने के लिए, अपने उसको रेरा तो कुछ पूछेगा नहीं. And still if you want to allow him, then if the actual cost can be allowed proportionately, not entirely togetherly in this particular, but it is subject to lot of litigation and debate, because there is currently the position is only ASR value needs to be allowed. B is estimated amount of premium, all types of premium which you pay to the government, state government, any local authority, that needs to be included in the estimated cost. Then acquisition cost, any TDR is available, he is going to acquire any cost TDR, and that needs to be mentioned in this particular estimated cost column. Any amounts payable to state government, D point, you can include by way of stamp duty, transfer charges, registration fees, etc. Everything can be included here. Next is estimated land premium payable as per ASR for redevelopment of land owned by the public authority. So any premium paid for redevelopment of land can be included here in this particular column. F. F point deals with the rehabilitation. Any scheme, rehabilitation scheme, redevelopment, या कोई भी चीज है जिसमें सोसाइटी redevelopment हो, या कोई भी ऐसे हो जिसमें मोर देन एक सेल कंपोनेंट हो और एक रिहैब कंपोनेंट हो, तो उसका रिलेटेड जो कंस्ट्रक्शन कॉस्ट है वो यहाँ पे आएगा, बट द एस्टिमेटेड, एंड दिस फिगर कैन बी ऑब्टेन्ड फ्रॉम द टेबल ए ऑफ इंजीनियर सर्टिफिकेट. वहीं से ये फिगर आना चाहिए. So reason behind separating estimated cost and actual cost is here only the estimated construction cost of rehab building by engineer यहाँ पे आएगा बस, बाकी कोई भी actual cost of chartered accountant नहीं आएगा. It is only the estimated cost needs to be mentioned of engineer. So no comparison to be done, directly form 2 से figure लेके यहाँ पे insert करना. Then further estimated cost in relation to the rehab component. Estimated cost construction का जो है वो इंजीनियर सर्टिफाई करता है. उसके अलावा जो है टेनेंट को अल्टरनेट अकोमोडेशन देने के लिए जो लगेगा, ओवरहेड कॉस्ट है या फिर ट्रांजिट अकोमोडेशन है, वो सारा कॉस्ट है, वो भी यहाँ पे प्रमोटर से लेके यहाँ पे इंकॉर्पोरेट करना है. That is readily available. We have a predefined construction this rent amount, and it depends on the number of years going to take to complete. उससे tenant से multiply करके वो estimated cost यहाँ पे बन जाएगा. Then any security deposits, any premium pays for that rehab component, but non-refundable. No, it should be non-refundable component. Many cases, in case of society redevelopment, there is refundable to a huge cost, but it will be refunded at the time after 4 to 5 years, and it initially becomes a huge cost. So such amount which is non-refundable needs to be incorporated here. But in case of refundable and it is a huge cost as on the date, still you can include, then you have to include it in income also to have a parity. Otherwise there will be an issue and it won't be matching in the as a project cost. So you need to incorporate it properly in your certificate. Estimated cost of ASR linked premium fees, charges and security deposit, like I said, you have to incorporate. And then any other cost including interest. Now the rehab component for rehab construction, we have a separate rehab this funding facility. So in that case अगर interest है उस पे तो वो allowed है. Interest on purchase of land not allowed. Loan for away for land, it is not allowed. But yes, interest on borrowing done specifically for construction of rehab component is allowed, but it should be specifically for rehab component. Otherwise if it is not specifically, you have to appropriately bifurcate. अगर वो भी वैसा रिहैब में लगा रहे हो तो वो प्रॉपर बाइफर्केशन लेना पड़ेगा कि रिहैब कंपोनेंट का कितना है और उतना ही यहाँ पे इनकॉर्पोरेट करना. So that completes your total land cost. Why rehab cost is included, construction cost? Because it is considered in lieu of land. You're getting the land free and you are constructing the sale building. So that is the reason it is considered, that construction cost is considered as a part of land cost. Next is development cost or cost of construction of building. अभी ये construction of building means what? The sale component, not the rehab component. So here you have sale component. Here also estimated cost certified by engineer ही आएगा. CA का ये पूरे estimated में कोई भी relevance नहीं है. Cost incurred on additional items not included in estimated cost. I had mentioned earlier वो जो additional items का जो cost था वो टेबल सी से लेके यहाँ पे डायरेक्टली हम लोग को इंकॉर्पोरेट करना है. उसका कॉस्ट और एक्चुअल में भी सामने आएगा. मैं दिखाऊं. See here they have given that it is as per engineer cost. Now in this point estimated expenditure for development of entire project excluding cost of construction of above, मतलब सेल बिल्डिंग के अलावा जो अदर एस्टिमेटेड कॉस्ट है such as consultant fees, salaries of the employees, साइट ओवरहेड, डेवलपमेंट कॉस्ट, ड्रेनेज, इलेक्ट्रिसिटी, ये सारा जो चीज है उसका भी कॉस्ट प्रोजेक्ट को एलोकेट हो रहा है तो वो यहाँ पे आएगा. बट एन इंपॉर्टेंट चेंज, पहले एक्चुअल कॉस्ट ऑफ इक्विपमेंट, सी हियर दिस एक्चुअल कॉस्ट ऑफ इक्विपमेंट पहले था बट अब उसको चेंज करके absorbed cost attributable to this project of machineries and equipment to be included. तो अभी इससे क्या हो गया, अगर मैंने मशीनरी परचेस किया है उसका मैं एंटायर कॉस्ट ये प्रोजेक्ट में लगाऊंगा, दूसरे प्रोजेक्ट में लगाऊंगा, ऐसे नहीं चलेगा. That machinery for how much time, for how much it is attributable to this project, only that part cost needs to be considered and not the actual cost. So this is an important change made by authorities. Next is estimated taxes, cess, fees, charges, premiums, interest payable to any statutory authority to be incorporated here. Last point, interest payable to financial institutions, scheduled banks, NBFCs on money borrowed for construction. So all the interest for the construction of the sale component, whatever interest you have borne, you have to incorporate that amount here and not the principal amount. Principal amount is automatically, once you avail the loan, it is automatically getting included in the form of the construction cost. Hence, you don't have to again include the repayment of principal loan. You just have to include the interest repayment of that cost as a part of the cost. So that completes your total cost. Above you have estimated cost. Here you will get the total estimated land cost and the development cost. So there will complete the total estimated cost of the project. Then in that you don't have to include pass-through charges or indirect taxes is to be excluded, because as per the act and the rules you have to give a separate record of the maintenance collected or such charges, pass-through charges to the association of allottees. But whether GST will be considered as pass-through? No. If you are availing 5%, if you are paying 5% or 1% liability, then ITC is not allowed. So ITC is not allowed. So 5% का तो वो pass through हो गया, लेकिन जो ITC है that will be part of your project cost because you are not setting it off against any liability. Hence, it will become your construction cost. Next is estimated cost shall be revised through correction application. You all know that we have to, if you want to revise, you have to pay 5,000. Table B now comes to the actual cost. Actual cost is exactly the same. So no need to go in detail. You just जो भी उस तरह estimated है उसका actual ये column में आ जाएगा. बस change एक ही है. एक तो rehab में हो गया change, and that is that while entering the actual cost of construction of rehab component, we have to compare. Now what we will compare? The actual cost as certified by engineer in his table A and table B, and actual cost certified by chartered accountant, whichever is lower. Before the amendment, the position was estimated cost of engineer and actual cost of chartered accountant, whichever is lower. And उसमें क्या होता था कि estimated cost तो हमेशा higher ही होगा, and actual cost is based on the actual position of the as on date of certificate. So somewhere there was not parity. अब यहाँ पे क्या होगा कि 100 का बिलिंग हो गया तो 100 का कॉस्ट सीए सर्टिफाई करेगा और 80 का यूटिलाइजेशन हुआ है तो एक्चुअल कॉस्ट इंजीनियर 80 का सर्टिफाई करेगा एंड विच एवर इज लोअर 80 will be allocated to the current cost as on this particular date of certificate. So that is the major difference in actual cost. Rest everything remains the same. The same position is in the actual cost to be certified by for the sale component. उसमें भी ऐसे ही ये दो का ही comparison होगा and not the estimated cost and actual cost. So that completes your total cost of the project. Here you will get actual cost. There you got the estimated cost. You just have to take the proportion here. An amount which can be withdrawn from the designated bank account is that proportion, that percentage you have to apply it on the estimated cost, which will again give you the actual cost incurred only. So amount that can be withdrawn is actual cost incurred. That's it. But 0.6 less amount withdrawn till date of the certificate. Subsequent registration के बाद subsequent certificate में वो withdraw करते जाएगा बैंक अकाउंट से, तो वो amount जो withdraw किया है वो यहाँ से माइनस होगा and you just have to give the limit, the balance limit that इतना अभी ये दिन पे इतना खर्चा हुआ है उसमें से इतना उसने withdraw कर चुका, अभी आगे ये सर्टिफिकेट के अंडर he can withdraw so and so amount. So that is very important, that this limit, point number 7, is very important, and banks keep a track of this limit and they stops further withdrawals. Hence it is very important that this certificate needs to be obtained in advance, otherwise they will suddenly stop the withdrawal and at least we will take 15 to 20 days for verification, then only we can issue the certificate. So it is better to on the part of the promoter to act proactively, and you, if you are handling the updation of the project, then you should keep a track of the limit also. And as a form 3 issuing CA, you should keep the track of your earlier limit. Pass-through charges or indirect taxes not included in the incurred cost of the project. Next is table C. We have completed 2 tables. उसके बाद है table C. Table C में statement for calculation of receivables from the sales of the real estate project. This is not new table. What is new is now this table is applicable for new projects also. Earlier also एक सर्कुलर उन्होंने निकाला कि प्रमोटर को डिस्क्लोजर करना है सोल्ड अनसोल्ड का डिटेल्स और एक फॉर्मेट दे दिया, वो पोर्टल पे अवेलेबल है डाउनलोड के लिए, बट उसमें वो क्लियरली लिखा दैट दिस डिटेल शुड एग्जैक्टली मैच विद दिस टेबल इन फॉर्म 3, बट एज पर रूल्स till date the rules are not yet amended and this table is applicable only to ongoing projects, but in the regulations now they have rectified, it is applicable for ongoing also and new projects also, but rules still remain unchanged. So currently we have to follow this only. सोल्ड इन्वेंट्री है, उसमें तुम लोग को फ्लैट डिटेल्स देना है, फ्लैट नंबर देना है, कारपेट एरिया मतलब रेरा कारपेट, यूनिट कंसिडरेशन एज पर एग्रीमेंट और लेटर ऑफ अलॉटमेंट, व्हाटएवर इज द अमाउंट इट शुड बी इंक्लूडेड हियर, एंड अगेंस्ट दैट how much is the amount received and what is the balance receivable. So unit consideration as per agreement or letter of allotment and amount received does not include pass through charges. Again अगर GST component है, stamp duty है, वो सारा इसमें नहीं आएगा. Unsold inventory, flat number, carpet area and as per RR rate on the date of the certificate, that can be easily available on the portal also of IGR, and you can get it from the promoter also. So these together we require sold and unsold inventory, and then we have table D. Ab table D mein there is comparison between balance cost and receivables. Now what is this comparison? It is just comparing कि कितना मेरे पास रिसीवेबल्स आएगा ये प्रोजेक्ट में एंड कितना मैं कॉस्ट खर्चा करने वाला. सो ये जो कंपैरिजन है ये ऑनगोइंग के टाइम पे बहुत रिलेवेंट था, बिकॉज क्या हुआ था तब एज पर एक्ट 70% डिपॉजिट करना था सेपरेट बैंक अकाउंट, बट एज पर रूल्स उन्होंने बोला अगर ऑनगोइंग प्रोजेक्ट है तो आपको देखना है कि रिसीवेबल्स उस दिन पे 1 मई 2016 को रिसीवेबल्स जो आने वाले प्रोजेक्ट में एग्जिस्टिंग है और अनसोल्ड के ये टोटल का समेशन कंपेयर्ड विद द बैलेंस कॉस्ट वो प्रोजेक्ट में, अगर रिसीवेबल मेरे कॉस्ट से भी कम है मतलब ये प्रोजेक्ट में थोड़ा रिस्क है, so then you have to deposit 100% in separate bank account, but if receivable is more than cost then you have to deposit 70%. So this was applicable to ongoing matlab kya, right from the beginning I am saying ongoing means only those projects which are as per the first proviso to section 3, that is those who have not received completion certificate as on date of the commencement of the act, only for those projects they are called as ongoing. So here now this table is applicable for all, but only the fifth point needs to be checked for ongoing. Now within 1-2 years many ongoing projects might get completed, so currently we don't have to use this point number 5 for new project, only first 4 points are applicable for new project and all 5 points are applicable for ongoing projects. Yeah, give me 2 minutes.
Do you want to take the questions now, or you want break?
No, we can take. No issues. If any questions are there relating to this part, we can take.
It is there. Just I'll just read. The first question is asked by CA Dinesh Chaudhary. Is RERA registration applicable for sale of plot after development like road, sewage, light, etc.?
RERA registration is applicable before the acceptance of any money, any booking or sale. So if the promoter is selling the project after OC, then RERA registration is not applicable.
The second question is asked by CA Ajinkya Vaishambayan. How to generally treat the cost of construction to be given to the landlord in area sharing agreement?
Okay, so in case of area sharing agreement, there will be two form 3. The land cost will be taken, the land ASR value will be taken by the landowner in his form 3, and whatever I am giving to the landowner, the construction cost will be taken by the main promoter, because he's giving that incurring the construction cost, and that cost can be taken in my form 3, but the land cost will be taken by the promoter, that is landowner. However, it will be blocked till the time he sell the units, and there will be blockage of working capital, because generally they are allowed to sell at a later point in the project. So still now the position is that they have to obtain 2 separate forms.
Next question is also asked by CA Ajinkya Vaishambayan. If no sale is made by the developer till the proposed date of completion, so now how can we get the approval of allottees as there are none? Can the project extension will be allowed on self-declaration by the developer?
Okay, so there is one order recently released that if there is no sale till date in the project, you don't have to go for extension. Simply apply for change of date in the to the RERA by paying 5,000. It will allow you to change, because there is no sale in the project. No need to go for extension, because once you go for extension, your option is exhausted, and it will be considered as a regular project. If there is no sale, never go for extension, directly go to application for change. It will directly change your date. You can change it many times till the time you are not even accepting any booking. So that is allowed.
Next question is what if the actual land acquisition cost is more than RR? This is asked by CA Vallabh Joshi.
Okay, so I had earlier also mentioned, definitely land cost if more than RR, RERA is of the view that he should not be allowed to withdraw more than the RR value, because If he is allowed at the first instance the entire cost, then sorry, then he might withdraw the entire land cost from the project. So there won't be any responsibility on the promoter, that the land cost is itself withdrawn from the entirely from the project. So that is the reason there are two views, that the above cost can be recovered from the 30%, which he is allowed to use for whatever reasons. But you can allow the actual cost based on the proportionate basis during the life of the project. Then also you can give the stand whatever you have taken, but as per the rules strictly it is as per the ASR value, and whatever the land cost is been given, only those components are to be included in regulations.
Next question is asked by CA Dinesh Chaudhary. Sir, on money paid on development agreement, where to show in form number 3?
Money paid on development agreement.
Yeah.
Uh, I mean to say, you are giving the construction cost, right?
So there are certain possibilities wherein when a builder enters into a development agreement, he gives a certain area. Apart from that area, he also gives certain money as a consideration for acquiring the development rights. So might be he is asking that what should be the treatment of the amount which the builder is paying to the landowner apart from the area being allotted to him.
Yeah. So like I said, if the land cost, see, it is towards the land, it is towards the development rights. If I'm considering the ASR value in the promoter's form 3, then I cannot take that amount because it will be against the land cost. So again, a land cost cannot be taken twice. So if he is the promoter, if I am paying that, only the construction cost, entire construction cost can be availed at the in the form 3 of the promoter, as the land cost will already be taken in the promoter. That is the agreement between the promoter and the landowner. Based on that, they can adjust that from the 30% account later on. First, it is to be completely as per the form 3 regulations, that the land cost will be considered in the landowner, and construction cost will be considered in this promoter's. So he should adjust that in, he should together consider that as a construction cost together, and then only he can allow that in his form 3 in the promoter's form 3.
Vallabh, I think you have one question you can ask directly.
Yeah, as you have mentioned couple of times, many times what happens that whenever a builder enters into a development agreement with the landowner, some sort of area is being allotted to the landowner as a consideration in lieu of the development rights. So can a builder show that particular cost of the area as a development as a land cost in the sort of acquiring the development rights? Or it should
No.
be grouped under, and my question is about grouping, where to group the cost, either whether the cost is to be booked as a construction cost or it is to be booked as a land cost to the extent area is being allotted to the landowner.
Okay, so whatever area has been allotted, so you have to book it as a construction cost, because land cost will only come once, and that will be in his form 3 and not the form 3 of the promoter.
Okay, thank you, sir.
Yeah, I think you can go ahead now.
Okay. Next is table E. Now in table E, this is a new table. This was not there. In form 3, the role was restricted earlier only to the net amount which can be withdrawn from the bank account. So in clarification, one clarification by the ex-chairman and RERA authority earlier in 2017, clarification on CA certificate was issued. In that, they had clearly mentioned that the role of form 3 is restricted only to the withdrawal aspect, and not, they are not going to certify the end use of the funds. But now the it is of no use, though that clarification is of no use, because this particular thing, table E and further tables, extend the scope of form 3, and now form 3 also certify the utilization and the deposit part. So that is very important. Now double check on the promoter. Form 3 role is extended beyond the certification of only limit. So let us see in table E, designated bank account details. Here you have to mention the opening balance, deposits, withdrawals and closing balance with actual amount till date from start of bank account to till date from start of bank account. So any form you are issuing after 22nd December 2021, you have to include it, the designated bank account, the zero amount, opening balance will be zero if the new bank account is open, and current as well, the total deposits, withdrawals and closing balance. So this should exactly tally with the bank statement. But many will ask, what if he has taken other amounts in that bank account? See, he is not allowed to. If he is not allowed to, but if he is taking, we are only going to certify that 70%. So you have to give, just below this table, you have to give a reconciliation that so and so amount is for relating to our allottees. Let टोटल अमाउंट कलेक्टेड उसमें से अलॉटीज का कितना है, बाकी सारा जो है बाइफर्केशन दे दो, बात खत्म. सी वी आर नॉट गोइंग टू, अभी उसने जो कर दिया उसको रेक्टिफाई नहीं कर सकते, बट हम लोग उसको, वी आर नॉट द अथॉरिटी टू पिनलाइज हिम. इफ ही हैज कलेक्टेड अलॉटीज उस अकाउंट में किया, उसके अलावा दूसरा अमाउंट भी उसमें किया है, तो जो भी है अथॉरिटी बाद में देख लेंगे. So we just can give the reconciliation that this is the amount we have identified that it is of the allottees, and that amount we are going to comment upon. That's it. Next is, see these two lines. These two lines very well give and increase the scope of chartered accountant issuing form 3. I hereby certify that required proportion of money as specified in the act collected from allottees as specified in the act. In act only 70% is there. Collected from the allottees of the project unit as, see now they have used unit. They should have used apartment. What is defined in that? Apartment. Of the project unit as indicated in table C has been deposited in this designated RERA bank account. So ये line कभी नहीं था. तो अब अपने को ये भी सर्टिफाई करना है कि 70% डिपॉजिट या फिर 100% जो ऑनगोइंग है, जो भी है उसने डिपॉजिट किया है रेरा बैंक अकाउंट में. नेक्स्ट, फर्दर एक्सपांशन ऑफ स्कोप. आई hereby certify that promoter has utilized the required proportion of money as specified in the act collected from allottees for this project only for land and construction cost. मतलब एक तो प्रोजेक्ट के लिए यूज करना है और दूसरा लैंड एंड कंस्ट्रक्शन के लिए ही यूज करना है. सो इसमें स्कोप कितना बढ़ गया कि सिर्फ डिपॉजिट नहीं तो यूटिलाइजेशन भी देखना है. प्रोजेक्ट के लिए मतलब ये बड़ा स्टेटमेंट हो गया. अगर उसने दूसरे प्रोजेक्ट के लिए ट्रांसफर किया, दूसरे प्रोजेक्ट में लोन दिया, तो so these all things are not that easy because I am certifying that this amount is used only for project. So whatever it is, you have to mention the observation and comments in the given below table. एक G करके टेबल दिया, उसमें सारे ऑब्जर्वेशन और कमेंट्स लिखो, तो वो क्लैरिटी आएगा कि उसने क्या किया है, नहीं किया. So this is very important. Somewhere, see, giving the allottee is final unit is very important, but we as a professional should judge what is the stage, क्या हो रहा है, उसके पास पैसा है कि नहीं, वो सब कुछ अपने को बुक्स ऑफ अकाउंट्स देख के समझ में आता है कि what is the current stage, what is his history, any litigation going on. So accordingly change the interpretations and inference on which you conclude the certificate. There is no risk. I mean to say risk तो है, but इतना डर के सर्टिफिकेट इशू करने का जरूरत नहीं है, बिकॉज मोस्ट ऑफ द प्रोजेक्ट्स नाउ द प्रमोटर्स आर आल्सो अवेयर ऑफ द कॉन्सिक्वेंसेस. सो नाउ स्लोली दे आर कंप्लीटिंग द प्रोजेक्ट्स एंड देयर फोकस इज ऑन ऑब्टेनिंग ओसी और जल्दी से रेरा में से बाहर निकल. तो यहाँ पे ये इंपॉर्टेंट है. तो जब तक कोई प्रोजेक्ट स्टक नहीं होता है ना, डोंट वरी, देयर वोंट बी एनी इश्यूज फॉर द प्रोफेशनल्स. टिल नाउ महारेरा हैज नॉट टेकन एनी एक्शन अगेंस्ट एनी चार्टर्ड अकाउंटेंट और एनी अदर प्रोफेशनल. एक केस था, बट दैट वी विल टॉक लेटर ऑन. बट बाकी सबके कोई भी अब तक इश्यू नहीं है, बिकॉज ऑल प्रोजेक्ट्स आर गोइंग ऑन. In case of lab project, yes, there are disputes, there are issues, so that might crop up. But in that case also, you should certify with certain care. So that is very important. Next is table F. Table F, this is an additional table, new table introduced introduced in this particular form. And in this case, means of finance, तो रेरा को क्या expected है, that RERA is asking how he will manage this project, from where he will arrange the funds, what is his estimated cost, and comparing the estimated and the funds available, whether he will be able to complete the project. So what they have given 3 columns. Once they are asking the estimated at the time of registration, that is proposed and indicative. Now this is very important, that proposed and indicative करके it is very hypothetical figure. At the time of registration itself he has to identify में वो कैसे project manage करने वाला, वो मुझे बताना है. तो वो उसको किस पॉइंट्स में बताना है, ओन फंड्स कितना लाएगा, बोरोड फंड्स कितने होंगे प्रोजेक्ट में, और कस्टमर रिसीट्स कितने यूज करेंगे. कस्टमर रिसीट्स यूज्ड फॉर प्रोजेक्ट, ये वर्ड बहुत इंपॉर्टेंट है. तो टोटल फंड्स फॉर द प्रोजेक्ट, ये तीनों आइटम्स जो ओन फंड्स, बोरोड फंड्स, सिक्योर्ड अनसिक्योर्ड और कस्टमर रिसीट्स, तो ये आ गया. एंड फिफ्थ इज टोटल फंड्स फॉर द प्रोजेक्ट. सिक्स्थ इज टोटल एस्टिमेटेड कॉस्ट एज पर टेबल ए. अब बहुत सारे लोगों को क्वेश्चन था कि फॉर्म 3 में मनी बोरोड फॉर कंस्ट्रक्शन में अनसिक्योर्ड लोन का इंटरेस्ट आएगा कि नहीं. अब रेरा ने मींस ऑफ फाइनेंस में ही पूछ लिया कि बोरोड फंड्स है, अनसिक्योर्ड लोन्स है, मतलब रेरा खुद एक्सपेक्ट कर रहा है कि अनसिक्योर्ड लोन्स से कितना फंडिंग करेगा. सो दैट मींस अगर मैं उससे फंडिंग करूं तो उसका इंटरेस्ट कॉल एलिमेंट भी कॉस्ट में ऑटोमेटिकली आ जाएगा. सो इट इज नाउ जनरल एक्सेप्टेड प्रैक्टिस, यू कैन इंक्लूड दैट कॉस्ट in the project cost. So total funds for the project estimated करना है start of the registration. Then at the time of every certificate he has to give the estimate कि क्या अभी चल रहा है, and we are going to certify the actual. So borrowed fund जो भी sanction amount है हम लोग वो नहीं लेंगे, जो भी utilize किया है that needs to be mentioned. And customer receipts, see till now form 3 never dealt with customer receipts used for the project. We were certifying कि इतना कलेक्ट किया अमाउंट, बट यूज फॉर द प्रोजेक्ट ये हमने कभी सर्टिफाई नहीं किया था. तो अब ये भी अपने को करना है, ये भी लिखना है कि कितने कस्टमर रिसीट्स प्रोजेक्ट के लिए यूज किया है, और उस हिसाब से यहाँ पे रोल और रिस्पॉन्सिबिलिटी फॉर्म 3 का बढ़ गया है. सो प्लीज डोंट जस्ट इशू द फॉर्म 3 एंड अंडरस्टैंड दैट दिस दे आर एक्सपेक्टिंग लॉट ऑफ थिंग्स फ्रॉम दिस पर्टिकुलर फॉर्म. Last table is observation. There was no such table in our prior certificates. Now RERA also knows that there should be a specific provision for entering the comments and observations of CA, which is very important. So यहाँ पे तुम्हारे जो भी observations है, कोई भी cost consider नहीं किया है, वो सारे observations लिखो. तो उस हिसाब से अपने को later date पे समझ में आएगा कि इस certificate में हमने क्या stand. See, we provide a reasonable assurance, but अगर ये सर्टिफिकेट है तो इसमें जो कॉस्ट है वो अगर हम लोग को दिख रहा है बुक्स में उसने दूसरे प्रोजेक्ट के लिए यूज किया, then that may not be taken as a cost in this particular certificate. So that is very important. Again, agreed and accepted by promoter, ये point जो है this needs to be taken care of, and we need to take the sign of the promoter for issuing this certificate. Then only it will be considered as valid. So quickly let us go through the slides. We have completed the form 3. Like I said, subject clause is incorporated. Issued for RERA compliance, 7 tables introduced, certifying deposit and utilization for construction of project, counter signature of promoter is required. Table A, separate table for estimated cost at the time of registration of the project, subject to change. Only estimated cost of construction by the engineer to be mentioned. Additional items के लिए provision है, pass through charges नहीं include करना है. It can be revised to correction application, and absorbed cost of machineries or the equipments will be considered. So these are highlighted points of that particular changes. Separate table in actual cost table भी separate table दिया है. Minimum of actual cost of construction as certified by engineer and CA लेना. Additional items के लिए cost दिया है. Pass through charges इसमें भी नहीं include करना है, और absorbed cost of machineries and equipment लेना. Table C, statement, it is a statement of sold and unsold inventory. Pass-through charges on indirect charges should not be included in the unit consideration. So this also, table C is also over. Table D, estimated balance cost of complete, balance amount of receivables, sold, unsold, estimated unsold sales, total estimated receivables कितने हैं, और अगर वो 70 ongoing project है तो 70% और 100% का चेक करोगे. So सिर्फ फिफ्थ पॉइंट है वो ongoing के लिए एप्लीकेबल है, मतलब ongoing के लिए सारे पॉइंट्स एप्लीकेबल है और न्यू के लिए सिर्फ फर्स्ट टू फोर्थ. Table E, this is the new table given wherein the bank details, bank state should exactly tally with the bank details, bank statement as on the date of the issuance of the certificate. Table F, means of finance. We have seen this, that how he will arrange the funds for the project and what is the estimated cost of that project. Table G, what table G can contain? Any exceptions in the land cost and construction cost, any discrepancy in bank account operations, sold and unsold inventory में कुछ problem होगा, pass through charges अगर unit consideration में consider किया है, deposit and utilization of customer receipts, their exceptions, any other exceptions related to the project can form part of this. Now second last form, that is form 5. It is a short form, but still here also the scope is increased. In form 5, we had a subject clause right from the beginning. The only addition of the word is deposit. Earlier we used to certify utilization and withdrawal, but अब तीनों certify करना है, deposit, utilization and withdrawal, and they have given us separate table itself. So deposits के लिए अपने को एक table दे दिया. इसमें वो लोग क्या, उन लोग को क्या चाहिए, that how much amount is collected from the allottees, how much is allowed by the act, and how much is deposited in the RERA bank account. So your total amount collected from the allotted for this fiscal year and the cumulative also, that needs to be reported. How much is the percentage in second point, suppose 70% है तो 70% आएगा वहां पे. अमाउंट टू बी डिपॉजिट कितना करना चाहिए था डिपॉजिट, फोर्थ में कितना किया डिपॉजिट, एंड फिफ्थ में परसेंटेज ऑफ डिपॉजिट, एक्चुअल जो डिपॉजिट किया उतना उसका परसेंटेज, एंड सिक्स्थ में शॉर्टफॉल और एक्सेस. तो ये अपने को डिटेल देना है कि कितना शॉर्टफॉल है या एक्सेस है. अगर एक्सेस है तो कोई बात नहीं है, उसने रेरा बैंक में ही लिया तो इशू नहीं है, बट इट इज रिलेवेंट where in section 13 in case he is not allowed to accept more than 10%. So later on वो भी आ सकता है, penalties charge हो सकते हैं. So here for that purpose excess amount is collected is very important, and if there is shortfall he just have to mention that has the required proportion of money collected from allottees as specified in the act deposited in bank account. If no, please mention the amount not deposited. So how much is not deposited, that needs to be mentioned in this. So this table deposits deals with the deposits of the amount as per the proportion required by the act or the rules. Next is first to get deposit. We are going to certify three elements: deposit, utilization and withdrawal. Out of that, first was deposit, second is withdrawal. You will observe that here also they are asking opening balance of RERA bank account, total deposits, total amount withdrawn and closing balance. But if you will observe the change between form 3 and form 5, this is for this fiscal year and cumulative, both needs to be updated. There it was only right from the beginning of bank account to the certificate, so it was total cumulative, and here it is for the fiscal year also, and cumulative effect needs to be mentioned. But they have introduced a sub table also कि withdrawal है किया है ठीक है, लेकिन कितना विड्रॉवल है जो एक्सेस विड्रॉवल है. नाउ दिस इज वेरी वेरी cumbersome because here we have to track the date of the withdrawal and the excess withdrawal amount also. If you will observe, there are 3000 projects which are lapsed, and out of them many have completed also, but still there is considerable number of projects which are lapsed. Out of that projects, most of them have not obtained form 3. So in that case, all the withdrawals which are not under the umbrella of form 3 will fall under this table. So here the amount will appear when the withdrawal is in excess of the limit specified in form 3. एक ही फॉर्म होगा हर प्रोजेक्ट में, एक फॉर्म तो होगा ही, क्योंकि जो रजिस्ट्रेशन के टाइम पे ऑब्टेन किया, उसके बाद लोगों ने किया है. Next is utilization. I certify that it is utilized for the project. Again, there is a table that if it is not utilized, give the date-wise withdrawal. Now, date-wise utilization, not utilization. तो यहाँ पे क्या होगा मालूम है कि अगर समझो एक्सेस विड्रॉवल है तो ऊपर के टेबल में आया, लेकिन ऐसे जरूरी नहीं है कि एक्सेस विड्रॉवल है पर उसने प्रोजेक्ट के लिए यूज नहीं किया है. अगर वो प्रोजेक्ट के लिए ही यूज किया है तो नीचे वाले टेबल में नहीं है, और अगर उसने विद इन द लिमिट भी विड्रॉ किया है लेकिन प्रोजेक्ट के लिए यूटिलाइज नहीं किया तो नीचे वाले टेबल में है. सो दिस इज यू हैव टू डिपेंड, इट डिपेंड्स कि अगर एक्सेस है पर यूटिलाइज किया है प्रोजेक्ट के लिए तो नीचे टेबल में लिखने का जरूरत नहीं, अदरवाइज यू हैव टू गिव द पीरियड ऑफ डिफॉल्ट एंड द अमाउंट नॉट यूटिलाइज फॉर द प्रोजेक्ट. Again, there is any qualification or observation of the CA needs to be mentioned here, and it is very in particular relating to discrepancy. कोई form 1, 2, 3 में कोई भी discrepancy observe किया, that needs to be mentioned here. Then we have to take signature and promoter of the on this form also. Form 5, we are certifying the deposit, utilization and withdrawal. 4 tables and 2 tables introduced. Shortfall deposit amount to be mentioned. Date-wise excess withdrawal, like I mentioned that we have to mention date-wise excess withdrawals, and even date-wise non-utilization of the project cost to be provided, and counter signature of the promoter to be provided. So this is just an example of that particular table, table A deposits. See, a 50 amount was collected. Out of that, 70% to be deposited as per that. So 35 is the amount deposited to be deposited. However, I deposited 30 only. So there is, the percentage is 60%. So there is shortfall of 10%. So here the amount will be 5. That is the shortfall of the deposit, and you have to give it cumulatively also. Table B withdrawals. This is how the table appears, like I mentioned in the form. Table D, any comments, exception relating to the deposit, withdrawal, utilization will come here. Any discrepancy in form 1, 2 and 3 will appear here, and other exceptions related to project will appear here. So all the descriptions, observations, comments you have to mention here. Last form is form 4. Same, only thing is he is allowed to issue it as per layout, and the important words added in his certificate is that on the basis of my inspection. Earlier it was on the basis of certificate received from structural engineer I am certifying this, but nahi, RERA bolta hai कि on the basis of my inspection also needs to be mentioned here. So it is very important these words are mentioned here, and it has been completed in all aspects and is fit for occupancy. This is very important, because there was one case wherein the surveyor was then architect also in this project, and the project had received OC, but the architect certificate had given that it is completed, and still the project was not fit for occupancy. So RERA that officer held a multiplicity accountable, the architect accountable, and transferred it to the concerned council for disciplinary actions. So it is very important that such things were is not to be I mean to say incorporated in the certificate properly. It should be incorporated properly, and hence it was changed, and now it is that it is not only completed, but it is fit for occupancy, which needs to be certified by the architect. So in that case, even though the OC was received, then also professional was held responsible. So it is very important while issuing the certificate, we need to take extra care. So plot details, layout, latitude and longitude, area, news deleted from subject clause, certificate can be issued for the entire project, list of technical professionals. These are common in all the certificates. It earlier form 2 and 1 form 4. They were containing these things, but now it is deleted. And it is on the basis of the inspection and or certificate of structural engineer, and it is complete as per agreement for sale. See, agreement for sale word appears in this certificate, form 1, form 2, 2A, everywhere. So it is very important. We are not linked to agreement for sale, but yes, these professionals are linked to agreement for sale. Counter signature of promoter is required on this particular certificate also. Now, once we have completed all the forms, and this is the last thing, that whether the certificate needs to be submitted to the bank. This was one point of argument, and one was when you were confused. So what RERA Act says, yes, you have to submit. What MARERA rule says, yes. Then FAQ clarified that yes, original to be retained and copies to be submitted. But circular had released in 2017, it said that no, only self-declaration to be submitted, and it was somewhere not in line with the act. So now latest position is 28 December 2021. This was amended, and yes, you have to submit it to the bank at the time of withdrawal, and copies online to the MARERA. And every withdrawal means जब तक वो limit खत्म नहीं होता तब तक देने का जरूरत नहीं, वो लिमिट एक्सपायर हो गया, एग्जॉस्ट हो गया, उसके बाद नए सर्टिफिकेट्स देना है. एंड रिसेंटली महारेरा पब्लिक नोटिस इन द पेपर, लीडिंग न्यूज़पेपर, दैट ऑल द बैंक्स शुड आस्क फॉर दिस सर्टिफिकेट्स and it should be submitted by the promoter to the bank. So first 3 certificates should be submitted to the bank account at the time of withdrawal. So that's it. We have completed the registration and all the amendments and all the whatever part was there relating to the forms. We have completed everything. Thank you very much.
Well, just see any other questions are there. We can take the questions.
Yeah, just a moment.
There's one question. You have referred that in form number 5, we can also point out discrepancies in form number 3. I mean, as a statutory auditor, if we are going to point out the deficiencies or discrepancies in form 3 issued by other fellow CAs, how that will affect the other CAs who is issuing that form?
Okay, but the issue is that if he is not allowed to withdraw and we have find certain discrepancies in the RERA bank account operations, and still there is a good position in that particular form, then somewhere we have to comment on that, because as per regulation it has been strictly mentioned that the form 5 auditor has given this responsibility to comment. So ultimately what will happen if somewhere the project is stuck, then all the professionals will be held responsible, and in that case our if form 5 auditor is not having that particular comment, or even it is skipped, then because promoter has got that amount and he has withdrawn that amount on the basis of the form 3, So somewhere the responsibility is entirely on the farm, and it is clearly written in the regulations that it will lead to the disciplinary actions and even the membership, removal of membership. So such, and even the RERA can charge penalty. So it is in good interest that if the discriminate error on the part of the record, any certain errors, and then there it might be ignored. But a considerable amount, and he has given a amount which is beyond the limit, then it has to be reported, and we cannot help that it cannot be reported. So it should be reported in that particular form.
Can he rectify those mistakes in subsequent form 3? Is it allowed?
Yes, but once he has given, if it is impacting the limit, once he has given the limit, he cannot rectify that. So, and even if you will read the our main book, certificate on RERA released by Central, they had mentioned that even though rectification is being done subsequently, then also you have to report that certain things are being it was done and you have rectified it later. So that needs to be reversed. So such precautions were inserted in that right from the beginning at the national level. So somewhere it ultimately it will lead to misrepresentation to the final buyer. That is the reason we have to point out such discrepancies. They are even expecting it on form 1 and form 2. At least form 3 we can understand, but form 1 and form 2 also we can comment on that. It is very surprising.
Sir, I am having two questions. My first question is in many of the cases we have come across, the builders, those who are not very well organized, may get many difficulties in raising the finance through banking channels. So in those cases, they prefer private investors. So for the initial days, the arrangement works out as a lender and a borrower, but eventually at the end of the project, due to any of the financial difficulties, the builder, instead of repaying the loan, allot the units to the investor or the private lender. So how to deal those situations in while certifying form 3 and form 5? Because when the builder has received the loan, he has not deposited that 70% in the designated bank account. However, while certifying the Form 5, we have to give the accumulated figures for the entire project. So many a times it becomes difficult for the professional because the unit is being actually allotted. However, the 70% amount has not been deposited because when the amount was accepted, it was in the nature of loan.
Yes. So the issue is in this case, basically we had pointed out this issue while discussion with the RERA authority, that even in case of contractors who are into barter exchange and everything, how to consider that. But it is still a pending issue. But what will happen now? Anyhow, the repayment of loan is not allowed as project cost. So that unit allotted to him, subsequently he will become an allottee. Till that time, only the interest component, whatever is charged, it can be withdrawn from the bank account as a project cost. So you can clarify, you can mention in your certificate that there is instead of loan, against the loan, the repayment is done in the form of the units. So the units, so and so units are allotted to the party, and it has been considered in the subsequent certificates. You can consider it as a collected amount because the amount, it is not no longer available for sale, and against the loan is set off, you are repaying the loan and you are getting a customer booking. That is itself, you can show it later stage that it is a booking amount. So RERA can very well understand this is not a market buyer. It is the party which you regular deal with. So later on, any dispute will be taken as that yes, he was earlier the party, and he had given you loan. So logically, he becomes an investor. So he becomes an investor, and we have seen that later on such disputes are not being entertained because they are considered as co-promoters, because he's providing the money to the buyer and then he's building promoter and he is building the project. So it is a point of dispute, but as far as we are considered, our role is to just disclose whatever position we have taken. That's it.
And so my second question is, as far as table F is concerned, that means of financing the project cost, therein you have rightly pointed out that now the customer receipts utilized towards the construction are also part of the certification. But many times we feel it really difficult that one has to actually drill down that how the receipts have been utilized. So just a question was, can the figure of customer utilization be a balancing figure with a footnote that whatever the cost incurred first, whatever and first the same has been financed through own contribution, balance it is being financed through loan, and balancing figure of the remaining cost is being financed from the customer receipts. Will it be appropriate with a disclosure?
No, it won't be appropriate because this can be done in estimated cost. But in case of the actual cost, actual column, there we have to see. We are giving an annexure table C also. Therein we are mentioning how much is collected, and we are certifying that this amount is deposited in that bank account. So logically, the 70% should 100% be used for the project. So that amount is only the amount which is used for project. So we have that amount. But why I was saying that this calculation may differ, because some amount he might have transferred to other accounts, some might have he have transferred to different liabilities, pay off different liabilities. So अगर मैंने 100 रुपीज कलेक्ट किया अलॉटीज से, मेरे वो टेबल में आ गया, तो वही फिगर वही वहां पे आना चाहिए. अगर उसमें डिफरेंस है तो मुझे डिस्क्लोजर देना है कि नहीं, इसमें से पूरा उसने 70% नहीं यूटिलाइज किया, बट सर्टन अमाउंट इज this amount is not utilized for the project. So we have that figure, but we have to scrutinize the bank account also, how much is utilized for the project.
Thanks, sir. Thanks a lot, sir.
Welcome.
You can check the chat box or questions session.
Yes, sir. Yes, sir. Yeah, yeah.
Any other questions are there? Just see. Riyan sir, you have any questions in the meantime? Sriyan sir, you have any?
Roman sir, can I ask one more question?
Yes, Samir sir. Go ahead.
In Form 3, we have to certify the RR value of the unsold inventory also, the table C part 2. Now, in a particular case, what we found out is that the unsold inventory is on higher side, and the sold inventory is on, I mean, maybe 10 or 20% only, and 80% is unsold. So in that case, the RR value is so less that it is not going to cover the basic cost of construction also. So in that, I mean, if we consider the actual sale price, that is on higher side, and of course the cost will be covered including the profits. But while certifying Form 3, they want us to certify the unsold inventory and its RR value. So the cost of construction as estimated by the engineer was on higher side as compared to the sale price of the unit sold plus the unsold inventory ka RR value. So in such a situation, what as a CA, as a one CA who is going to certify Form 3, what we are supposed to do in that case?
Yeah. So is it a new project?
It's a new ongoing project. Correct.
Yeah. So in new project, it is just a figure to disclose. RERA is not at all comparing it that ये तुम्हारा ASR वैल्यू से भी खर्चा कम है, ज्यादा है, तो फिर तुम्हारा प्रोजेक्ट कैसे होगा, वो रेरा को भी मालूम है. वो इन फॉर न्यू प्रोजेक्ट दैट फिगर हैज नो रिलेवेंस एट ऑल. ASR वैल्यू इज जस्ट ओनली फॉर डिस्क्लोजर पर्पस. इतने सारे अनसोल्ड यूनिट्स है और इतने सारे सोल्ड है. ऑनगोइंग में उसका रिलेवेंस था कि अरे प्रमोटर तो आरआर वैल्यू जो सबसे लोएस्ट है वो कंसीडर करके भी उसका कॉस्ट ज्यादा है, मतलब ये प्रोजेक्ट कंप्लीट ही नहीं कर पाएगा. सो दैट इज द रीजन it was having a great relevance in ongoing project. But for new project, even though RR value is less and estimated cost is more, then also there won't be any issue, and we can certify. We don't have to take any or clarify, because like I said, in that particular table, fifth point is not at all applicable for new project. It is applicable only for ongoing project. So first four fields are only for disclosure purpose. That's it. So RERA won't judge new projects on the basis of RR value.
Sir, why I asked this particular question is that The moment we issue that form, there is a query from the bank who is financing that project, saying that, okay, look, your CA has certified something which, I mean, the project is not going to be profitable. That is what we can see from the form 3, and that's how the bank raises a query, and we had to clarify them that these are the only RR value which are presently shown as per the requirement of RERA, and these are not going to be actual sale price. So I mean, it posed difficulties for the builder in getting the finance from the bank.
Correct.
That's why
So
I asked the question.
yeah, that is the issue, but many of the bankers are not aware of what exactly it is, and based on this certificate, they cannot release the finance because we need to provide cash flows and everything in detail. Here, it is only a summary of means of finance, but actual cash flow and everything is in detail, so they cannot release. They, however, require more certificates, and they require the factual position on the RERA website to be mentioned. But this RR value has no relevance for new projects. So it will always be, because 3 to 4 years it remains unchanged. So it cannot give you a true picture of that project, and open markets value is obviously higher than the RR value. So in factual new projects, there is no relevance of ASR.
Okay.
Sir, there are no more questions. I think sir has already answered all the questions.
Srikanth sir, you have any questions?
No, continue.
Sri? Okay.
All doubts are clear, whatever in my mind.
Okay.
Our
If
CA is
there are
required
no,
to register. Our CA is required to register under RERA website.
No. Currently, no. In RERA, they are required to register. They sign through digital signature and there is a proper procedure. But as of now, we don't have to require. Only on the website, who is certifying form 3, his details need to be registered, and who is certifying form 5, that details need to be mentioned. The promoter has to mention while registering.
If our role is in any way, in a different way, suppose internal audit for the particular project, okay, or any other services we are giving as a chartered accountant for that project, then also we are not required to register under RERA.
No. Only registered agent is there, but for CAs and other professionals, no registration is required. Even we don't have any such thing or related party and everything. Only they have this thing is that you only form 3 and form 5 chartered accountant should be separate. That's it. Where RERA had specifically mentioned that associate concerns cannot sign. So here there is no such thing till now. They haven't mentioned any such rules and regulations. So currently, people associate concerns are also signing. As far as this should not be the position, it should be completely independent. What they are expecting, but in Act it is just a chartered accountant. So they have mentioned in regulations that it should be 2 different entities. That's it.
Okay, thank you.
now if all the questions are already answered, then we can go for a formal vote of thanks. I request past chairman of Navi Mumbai branch of WRC, CA Samir Gavli sir, to give the formal vote of thanks. Samir sir, please.
Thank you, Jomanji, for giving me this opportunity of giving vote of thanks to the learned speaker of the today's topic. And as his name suggests, Aditya Zantye, that A to Z, he has covered all the aspects of RERA, and he has, I can say, he has covered all the syllabus in his RERA ki Pathshala, as his name suggests. So, and he has covered everything that has been newly introduced in Form 3 and Form 5, which are more relevant to us. And for last 3 hours, we are listening to him, and the depth with which he has delivered his lecture and enlightened all the members of Panvel CP Study Circle. I think we should appreciate his efforts, and thank you very much, Aditya, for sharing your knowledge with all the members of Panvel CP Study Circle of Navi branch of WRC. On behalf of all of us, I propose a hearty vote of thanks for all the efforts and knowledge what you have shared with all the members. Thank you very much, Aditya, and thank
Thank
you,
you
the conveners of the Panvel CP study cycle. Thank you.
Thank you.
We can give a round.
We can give a round of applause definitely.
Thank you very much, sir.
Really, it was like a marathon because since 3 hours you are continuously talking about the subject, and I think it's wonderful, non-stop.
Non-stop.
So I think, as Srikanth sir mentioned earlier, after some point of time, we will have physical seminar in the subject again. I think this is a hot subject, and again, as I mentioned earlier, CP Directorate also sent a mail stating that in the month of May, we have to keep this RERA as a separate festival like RERA Maholsav and all, because there are some importance for this particular subject. So I think in the future we can meet each other, and definitely we will call you, and we will have some good physical physical seminar. And again, on behalf of Panvel CP Study Circle, we extend our thanks. We are grateful to you for your valuable time, and within a short span of time, you accepted our invitation and you delivered a wonderful lecture. Thank you so much again from our side.
Thank you very much to all the office bearers. Thank you.
I think with this, we can conclude our session. Vallabh, you can close our session. Okay,
Thank
take care. Bye bye.
Bye.